convictions. The court is not going to touch out-of-county holds, out-of-state holds, sign warrants on violations of probation or capiases for the most part. If you are a civilian, please pay attention. This applies to you. Please note that these proceedings are not only recorded, but they are live streamed on YouTube. For that reason, you need to have your full legal name listed if you are here and wish to be heard from. I've already advised an individual this morning and he's done so. He's changed his name to reflect his full legal name. You need to have your cameras off, however, and muted until the case that we're here for is called. You would indicate your presence by using the raise hand icon to indicate your presence. Once the court does see that your hand is raised, I will make a determination as to whether you are the listed victim. If you are the listed victim, then I will call on you and ask you a couple of questions, including whether you're just here to see what happens or whether you wish to testify. If you're anyone other than the listed victim, please note that the not on call on you. The only way that you will be heard from is if one of the attorneys calls on you to testify. Please do not interrupt these proceedings by either turning your camera on as a civilian or unmuting yourself. If I have to turn your camera off or mute you multiple times, you could be ejected from these proceedings without warning for interrupting. Additionally, depending on the severity of the interruption, you could be ejected from these proceedings without warning. That being said, I do have to take a couple of out of turn based on several reasons, one being medical reasons or based on these sorts of charges. And additionally, I do have a couple of attorneys who are permanently assigned to this courtroom versus attorneys who have to go to separate other courtrooms. I will call the attorneys who are not assigned to this courtroom first because they have other courtrooms to be in, and that is a courtesy. Please do not think that I'm giving them any preference or any other reason other than I'm giving them that courtesy. So let's get started. Out of turns at Paul Ryan. I believe they said they only had one individual this morning, correct, guys?
Right here, Your Honor.
All right, good morning, Mr. Mathis.
Good morning.
This is Mr. Mathis on the second look at Mr. Linder, first to you.
Your Honor, Mr. Mathis has resolved sentence on that. Based on that, if he wants to resolve this matter, he's obligated to issue that.
Okay, thank you, Ms. Edgley. Okay, so could you guys have a phone number so Ms. Edgley can call over to Mr. Mathis to see if he wishes to accept that, or Mr. Mathis, do you wish to accept the state's offer?
I didn't hear you, Your Honor.
Do you wish to accept the state's offer of an adjudication time served, or do you need time to speak to Ms. Edgley, your public defender, this morning?
No, I'll take the offer.
Okay, Ms. Edgley, so it's up to you. Do you want me to? All right, thank you. So Mr. Mathis, please raise your right hand for me, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
Larry Mathis.
All right, Mr. Mathis, again, it's my understanding that you wish to resolve your operating without a valid driver's license case, correct?
Yes.
Do you understand the charge against you?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs, sir?
No, ma'am.
Do you need more time to speak to your attorney, Ms. Edgley?
No, ma'am.
And do you understand you have a right to go to trial and fight this charge, but you're giving that up by accepting the state's offer?
Yes, ma'am.
And have you ever been treated for a mental or emotional illness, sir?
No, ma'am.
And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen that taking this plea shall subject you to deportation proceedings?
Yes, ma'am.
And how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, I accept your no contest plea is freely, knowingly, and voluntarily given, and I'll sentence you to an adjudication time served. I'll dismiss the traffic infraction and waive the late fees of $55. And Ms. Edgley, how much time do you want me to convert his court cost to civil lien? Okay, and I'll convert your court cost to civil lien. Mr. Mathis, what that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the to pay that off, sir.
Excuse me?
Mathis. All right, Mr. Romero, good morning, sir. How are you?
Good morning, Judge. How are you doing today?
Good, nice to see you.
Good to be back, Judge.
Do you have any information for me other than the 2 out of turns they asked me to take in the 1 Spanish interpreter case?
Let me try and go through this and let you know, Judge.
Sure, no problem.
Page On page 7, Ms. Vanessa Davidson wanted me to waive her appearance.
Okay, got it. Thank you.
8, Mr. Cabrera Nukumbi, we're going to require a Spanish interpreter.
Yes, they told me. Thank you.
Page 8, Mr. Virgil Ullman advised me that his family hired private counsel, but doesn't know the name of the private attorney.
Yes, that's Miss Lawson, and she's here in court. Thank you.
And Judge, Mr. Dejan Frazier is a refusal.
Okay, looks like an ad count, count 24. Any objection while we can't proceed?
Judge, unfortunately, I was not in a position here to see what are the other counts that he's being held on. So I'm kind of traveling a little bit blind as far as what he's been in custody for and how long. So I don't have that information.
Yesterday, some of his charges are pretrial violation.
Okay, so thank you so much. Mr. Worrell just advised he was on the docket yesterday. He's being held no bond on some pretrial warrant revocations.
No objection, Judge.
All right, thank you. So we'll proceed.
On page 12, Mr. Jason Danny is a medical reset.
Okay, thank you.
15, Mr. Nicholas Lang is a refusal. If it's first time, I'm asking for it to be reset one time, Judge.
Okay, thank you. Mr. Linder, state wish to be heard. Okay, thank you.
I didn't hear Mr. Linder say no objection.
He said no. He said no objection. Sorry, Ms. Worrell.
Is that Nicholas Lang that was a name reset?
No, that's a refusal.
Oh, refusal? Okay.
On page 15, Eric Klein wanted me to waive his appearance this morning.
Okay, thank you.
On page 16, Mr. David Hadler is a medical reset, asking for it to be reset tomorrow.
Okay, no problem.
And on page 17, Jose Hidalgo is still medical reset, Judge.
Okay, thank you. So we're going to delete Mr. Hidalgo. It's now been 74 hours. Whenever he's released from the hospital, we'll put him back on, okay?
Yes.
All right, thank you. All right, so let's do our main jail out of turns based on medical reasons. Page 13, Mr. Culver.
Yeah, approaching, Judge.
All right, Mr. Culver, good morning, sir. The court does find probable cause for driving with a suspended license, a habitual or revoked. Mr. Linder, first to you, sir.
Recommending ROR with pretrial.
All right, thank you. Mr. Romero, that was an ROR to pretrial recommendation from the state.
Judge, in that case, no objection.
All right, thank you. Mr. Culver, I am going to release you to pretrial release. That means that you're going to get out today, but you need to call in tomorrow before 11 a.m. Please provide your phone number to pretrial before I continue with my orders.
If you remember. Tomorrow. Judge, he doesn't remember, so I'm instructing him tomorrow when you call and see that little page right there in the phone. Call him before 11 a.m. You give him your contact information.
Yes, sir. Yes, ma'am.
All right, so Mr. Culver, you're going to be released today. You have to call in before 11 a.m. When you call in, not only will you have to give a good phone number where they can reach you, but an address where you'll be staying. Do you understand?
Yes, ma'am.
All right, you cannot drive without a valid driver's license. Do you understand? All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, Mr. Culver. Call in tomorrow, please.
That's it.
All right, next is Mr. Natson on page 15, who's another out of turn.
Approaching, Judge.
Mr. Natson, good morning, sir. All right, the docket and the findings appear to be incorrect. According to the police reports, counts 1 and 2 should have been a burglary with an assault or battery. Do both sides agree?
Yes, sir.
Yes, sir.
All right, thank you. So based on there being no objection, I do make a finding of burglary with an assault or battery on counts 1 and 2. I also am making a finding of proof evident presumption great on counts 1 and 2, and I am going to hold him no bond on counts 1 and 2. Count 3, aggravated assault with a deadly weapon. I do find probable cause as well. Mr. Linder, first to the state with counts 3 and any priors.
One moment.
And the problem was if I may, if I
Sure, go ahead, Ms. Edgley.
so was it an assault It appears from the phone call that the back happened after the not hospital, that's exactly what happened. So I took the phone hospital but there's no indication that this person is attached to that.
On count one, Ms. Edgley, for the second victim, he threatened to kill both of the listed victims while he was inside the house while he allegedly battered one of them. So based on that assault, that threat to kill while he was inside the home and allegedly battering one of the victims out of 4, I am going to maintain my finding of probable cause, okay? Okay, thank you. So, Mr. Linder, whenever you're ready.
Yes, thank you, Judge. 2011, resisting without violence.
I just want to let
Iron burglary dwelling in Grand Theft. We violated immigration, sentenced to 6 years state prison. Judge Elias mentioned no bus hold order on meeting 2. The state recommending a $7,500 fine.
All right, thank you. Mr. Romero, sir.
just to reiterate the point, we couldn't hear anything what's going on, but I just want to let the court be aware. In speaking with Mr. Natson, I do have some concerns. He has several mental health issues and also medication that he needs to be on. So we're going to be asking both the mental health screening and a medical screening. We're going to be asked to be provisionally appointed. Mr. Natson wanted me to ask the court, basically he needs help, but he does not believe he can get that help from the inside. He wanted me to ask the court to exercise his discretion in having him have some sort of reasonable release conditions at level 1, so he could get the appropriate help from the outside. So that is what the request I'm making on his behalf today.
Thank you. That'll be denied based on the allegations. There being 4 listed victims, as I said on the record, alleged that one of the victims was actually battered inside the home while he allegedly told 2 of the listed victims he was going to kill them and then allegedly try to run over one of the said victims with his automobile. I am going to continue that no bond hold on counts 1 and 2. He'll have to file an Arthur hearing motion with his division judge. Sir, you cannot return to the, where did he go?
Judge, we're going to have to, a brief moment, he just right now collapsed.
Judge, I have a question.
He did what? Yes.
I have a question. Because of the booking error, count two and 3 are the verbal assault.
No, 1 and 2.
Right, but I have to get it correctly, so you don't even look by inspection. So count 1 was booked correctly, but count 2 and 3. How they have count 3 listed as the same as count 1, but count 3 should have been booked as the same as count 2.
So,
See that?
no, let me go to that page.
Count the first sentence out, negative result, the house of the so count 2 and 3 should have been booked as the earlier result of that. We would count 3 as the same as count 1. So per the PC, count 2 and 3.
Okay, so I already changed it on the findings as count 1 being the bird bat. And so just change the numbers.
Okay.
I'll just change the numbers on here so it doesn't mess the jail up.
Murphy's Law.
Good morning, Judge. I'm back.
All right, not a problem. So is Mr. Natson still there?
I believe we had a medical issue, Judge. Right now, he's being seen. I know they're right now trying to talk to him and treat him, Judge.
All right, not a problem. So what do you want me to do? Because I've already made the findings for the bond, but do you want me to just put him on the end of the docket, or do you want to waive his presence?
Judge, I know at this time, the court having made a finding and holding him no bond on count 1 and 2, and we did speak to Mr. Natson about that as far as what remedies he's going to need to take at this time. reference, he's being held no bond. So at this time, I'll waive his appearance, Judge.
All right, not a problem. I'll also sign that medical order so we can make sure that he is treated expeditiously and that mental health screen. And order of return, no victims contact with any of the 4 listed victims allegedly in the home, no firearms, weapons, or ammunition while the case is pending. And I will provisionally appoint your office to represent him during the pandemic, sir. Anything else on his case?
Not a,
I do need to set bond, sorry, on the aggravated assault. I'll set that at $7,500. And that's actually count 1. I had it backwards. All right, anything else, Mr. Natson? All right, thank you. All right, so just give me 1 minute to sign these 2 cases. All right, so these are these. All right, so do we have our Spanish interpreter case person yet? No, I don't think so. Okay, so let's call Mr. Kirsch's case, Ms. Basant on page 1.
Ma'am,
Yes,
good morning, Judge. So, Conti has 3 for Spanish interpreter.
oh, okay, so whenever the Spanish interpreter gets here, we'll take those cases too, okay?
All right, thank you.
Okay, thank you.
Conti's at no brow, John.
All right, thank you. The listed victim is here and you do have an attorney representing you, Ms. Basant. Good morning. The court does find probable cause for battery, harm, or disability, domestic violence. Mr. Linder, do you want me to hear from the listed victim first?
That's fine, Your Honor.
All right, thank you. So, sir, good morning.
Good morning.
All right, you are the listed victim, correct?
Correct.
All right, do you wish to say something to me or just see what happens?
I do wish to say something.
Okay, so please raise your right hand for me, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You can put your hand down and please state your name for the record now that you're sworn.
My name is John Rochelle.
All right, sir, thank you. You are without an attorney, so I need to advise you that you previously spoke to an attorney. So anything you say today can be used against you at a later date. Do you understand?
I do.
Okay, what is it that you wanted to tell me?
I just wanted to let the court know this is definitely outside of Ashmead's character. This isn't known of hers. First time some incidents like this have occurred. And, you know, she's an outstanding citizen and she's a great person. So I want to let them know.
You want to have contact?
And I do want to have contact.
All right, thank you, Mr. Linder. Any questions based on his testimony this morning?
Yes, Your Honor, briefly. Sir, you have a son that lives in the home? How old is he? 3, and he was present when this occurred. He was sleeping in another room?
Yeah, yes, even
Nothing further.
Okay, thank you. Mr. Kirsch, any follow-up questions based on the state's line of inquiry or his testimony today?
No questions of Mr. Rochelle.
Okay, thank you. Mr. Linder, first to you.
Thank you, Your Honor. Mr. Kirch and I have agreed to $1,000 bond if that's acceptable to the court. I see no history. I think where we have, we're going to need the court to resolve the matter is, I am asking for an order of no victim contact. I do have a concern that there is a 3-year-old living in the home that was present in the home, though sleeping, when this alleged incident occurred.
Okay, thank you, Mr. Kirsch.
All right, again, just for the record, I no objections to finding a PC. Ms. Basant resides in Broward County for 10 years at the incident location with Mr. Rochelle. She does have a heart condition and various other medical conditions supported by her family. Mom and dad and younger brother is present in the courtroom this morning. Mr. Rochelle wants contact. He did not want her arrested. He does not want her prosecuted in any other way. We're asking the court to accept the agreed bond amount of $1,000 and to allow contact between Ms. Basante and Mr. Rochelle.
All right, thank you, Mr. Kirsch. I am going to accept the parties agreement at $1,000. I am happy We're going to set no victim contact, direct or indirect for now. Ms. Basant, based on the allegations, the level of violence, that there was allegedly 4 to 5 fist punches thrown to the alleged victim's face, and then you allegedly wrapped your hands around his neck and scratched him while there was a 3-year-old child sleeping in the home. So there needs to be a cooling off period. Do you understand that you cannot live with them? Call him, text him, email, social media, send letters, or have a family member or friend send a message to him for you.
Yes, Your Honor.
All right, or any other means of communication that I have not said. Do you understand?
I understand.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand? All right, thank you for being here, Mr. Rochelle. I understand your position, but for now, there needs to be a cooling off period. I hope you understand. Is there anything else that we need to address on her case?
No, Judge.
No, Your Honor.
All right, thank you. Take care, Mr. Kirsch. Take care, Mr. Rochelle. Good luck to you, Ms. Basant.
Thank you, Your Honor.
Okay, perfect. So let me take the one other out of turn case, and then we will call the Spanish interpreter. Is okay? Okay, yes, they said 3. Okay, thank you. So let's call Ms. Coleman on page 8, Miss, oh wait, that's the wrong paperwork. Mr. Coleman on page 8, Ms. Lawson has been patiently waiting as well. All right, good morning, Ms. Lawson.
Good morning, Your Honor. How are you?
Fine, how are you?
Good, thank you. I
Where is Mr. Ullman?
believe he's at the main jail. There he is.
All right, thank you. All right, so Mr. Ullman, good morning, sir. The court does find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you. Does he have any priors on the state's recommendation?
Judge, I saw no history. I'm recommending $1,000 bond and no victim contact based on the level of violence.
Thank you. Ms. Lawson, ma'am.
Your Honor, there's actually, the alleged victim is his wife. She is currently on the Zoom. I'd asked to take testimony from her. Her name is Gordana Ullman.
Okay, just give me 1 minute. Let me verify the name.
She just turned her camera on.
All right, Ms. Ullman, there you are. Ms. Ullman, good morning, ma'am.
Good morning.
Okay, you need to be by yourself so I can make sure that your testimony is not being influenced. There's somebody else with you.
Yes, but my sister-in-law, she's leaving the room right now, but I don't know how to use this touch screen, so that's why I'm here by her house, so.
No problem. I just need to make sure that your testimony is yours and yours alone.
Okay.
All right, ma'am. Did you wish to say something to me, or are you here to just see what happens?
No, I wanted to speak because I can't believe.
Okay, so hold on. So please raise your right hand for me then.
Okay.
All right. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you. You can put your hand down and state your name for the record.
My name is Gordana Ullman.
All right, ma'am, you are the listed victim in this case, and you are here without an attorney. So I need to advise you that anything you say may be used against you at a later date. Do you understand?
That's fine.
All right, Ms. Ullman, what is it that you wanted to say to me?
Well, I wanted to say that Virgil and I have been married since we were teenagers. This has never happened to us. We had a disagreement and it escalated. But at no time did I feel threatened by him. And I told the police this, and I don't understand why they even removed him out of the house. I told them I don't want to press any charges. I told them that I don't feel threatened at all.
All right, thank you, ma'am.
I want my husband home.
All right, thank you, Ms. Ullman. Mr. Linder, does the state have any cross-examination questions for her?
Yes, Your Honor. Yes, Your Honor. Ms. Ullman, you had your grandson take a video recording of you? Is that correct?
Yes.
And in that video, you described the manner in which Mr. Ullman punched you in the face?
Well, we were in the car. He was in the car and
Ms. Ullman, please answer the question that's asked of you, okay?
Yes.
It's just a yes or no. In the video, do you describe how Mr. Ullman punched you in the face?
It happened so fast that now I can't.
Ma'am, it's a yes or no. In the video, do you describe how Mr. Ullman punched you in the face multiple times?
Yes.
Did you also show the marks on your face that were left as a result of Mr. Ullman punching you in the face?
This never happened before.
Ma'am, it's a yes or no.
Yes, I believe I did.
Okay. And did you advise your daughter that you were struck in the face by Mr. Ullman?
No, I came back in because I was upset and angry, and it just escalated to other things. I did not tell her to call the police. I even told the police I don't want to file a
Ma'am,
Ms.
restraining
Ullman,
order.
please answer the question as directed, okay? Or we'll have to cease your questioning. Do you understand?
Ma'am, I'll
Not really,
repeat.
but
Ma'am, I'll repeat. My only question was, did you tell your daughter that you were struck in the face by Mr. Ullman?
yes, I did.
Thank you. One moment, Your Honor.
But can I say something, please?
Hold on, Ms. Ullman.
Your Honor, I have no further questions.
Okay, thank you. Ms. Lawson, did you have any follow-up questions,
I
ma'am?
just had one follow-up question. Ms. Ullman, this is Ms. Lawson. Do you want contact with your husband?
Yes, I want him home. That's why I'm here now on this video phone, so I can have him back home.
And do you fear for your safety at all?
No, not at all. That's why I'm here.
Okay, thank you.
I have phones all over in my house. If I was scared for my life, I would have called. I wouldn't have needed my daughter or anybody to call the police for me. When the police was at my house, I told them I don't want to press charges, and we had a disagreement, and it escalated, unfortunately. But at no point in time was I scared for my life or my well-being.
Thank you very much.
Thank you, Ms. Ullman. I'm going to mute you now, but you can leave your camera on. Mr. Linder, first to you.
Your Honor, while I see no history, I am recommending $1,000 bond in contact. I certainly recognize the request made by Ms. Ullman this morning, but I am concerned not only based on the level of violence, but also despite the fact of what she's advising the court this morning, she apparently was concerned enough to advise her daughter that she was struck in the face by her husband. She was concerned enough to involve her grandson to video record and take photographs of the injuries she suffered, and also specifically describe how she was struck in the mouth multiple times by Mr. Ullman, Your Honor. Nothing further.
Thank you, Ms. Lawson.
Thank you, Your Honor. Mr. Ullman is 60 years old. As you heard, he has no prior criminal history. He's lived at the address on the probable cause affidavit and plantation for the past 20 years. You heard from his wife now that how long they've been married and that nothing like this, there's been no issues ever before. She is asking for contact. We are asking, Your Honor, in light of all that, he also is employed. We're asking for you to release him ROR and allow contact.
Based on the level of violence, he's not a candidate for straight ROR, Ms. Lawson. Another request.
Then we would ask for the $1,000 bond.
All right, thank you, ma'am. I am going to set the bond in the amount of $1,000 based on the allegations in the report that she was allegedly struck in the face 3 times with a closed fist. And she was so concerned to the point that she got her grandson involved to allegedly take video showing not only the injuries, but the alleged way that she was struck multiple times. I am going to impose a no contact at this time so that there is a cooling off period. You can always file a motion with your division judge, sir, but there needs to be a cooling off period based on these allegations. That means that not only can you not live with Ms. Ullman, you cannot call her, text her, email, social media, or have family member or friend send a message to her. Do you understand?
Yes.
All right, sir, or any other means of communication that I have not listed. Do you understand? Mr. Ullman?
Yeah. What was the question?
Do you understand that you cannot have any contact, direct or indirect, with your wife?
Yes.
Okay, and I just described the means and methods of communication, and that includes any other means that I have not said, which includes that you cannot live with her until further order of the court. Do you understand? You also cannot possess any firearms, weapons, or ammunition while the case is pending based on domestic violence nature. Do you understand? All right, is there anything else on his case that we need to address from either party?
No, Judge.
No, thank you.
All right, thank you, Ms. Lawson. Good luck to you, Ms. Ullman. Thank you for being here.
Judge, can we do someone else out of order for medical reasons?
Sure.
Can we do on page 3, Judge, Miss Shakira Johnson?
Okay, sure. Mr. Plan, did you check in with the deputy so I know what case you're here on, sir? Oh, okay, not a problem. Okay, no problem, thank you. All right, Ms. Johnson, good morning, ma'am. The court does find probable cause for trespass. Mr. Linder, it is at a Solo gas station. Never heard of it, guess it's new. Does the state have an offer she wishes to resolve?
Adjudication time served, no return, Judge.
Judge, I heard the offer and I spoke with Johnson. That's exactly what she wanted to do in exchange for a no contest plea this morning.
All right, thank you. Ms. Johnson, please raise your right hand for me to the best of your ability, ma'am. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You can put your hand down and please state your name for the record.
Kira Johnson.
All right, ma'am, it's my understanding that you wish to resolve your trespass case, correct?
Correct.
Do you understand the charge against you?
Yes, I do.
I've been advising you're not feeling well, but are you feeling well enough to go forward with this plea?
Yes.
Is anyone forcing you to resolve your case?
No.
Okay, and are you under the influence of alcohol or drugs, ma'am?
No, ma'am.
Do you understand you have a right to go to trial and fight this charge, but you're giving up that right by accepting the state's offer of an adjudication time?
Yes, I do.
Right, and have you ever been treated for a mental or emotional illness, ma'am?
No.
And I'm not asking if you're a citizen, I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking this plea shall subject you to deportation proceedings?
I understand.
All right, and how do you wish to plead, ma'am? Guilty or no contest?
No contest.
All right, ma'am, I accept your no contest plea is freely, voluntarily, knowingly given, and I do find a factual basis based on the probable cause affidavit. I am going to sentence you to an adjudication time served with an order of no return to the Solo gas station. How much time does she need to pay, Mr. Romero?
I'm going to be asking for a civil lien, Judge.
All right, not a problem. I'll convert your court cost of prosecution, PD application fee to a civil lien. What that means, Ms. Johnson, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off. Good luck to you, ma'am. If there's nothing else, you should be released, okay? All right, so we do have the Spanish interpreter in the courtroom. Thank you for joining us.
I believe it would be on page 9, Judge at Maine. And that person's name is Mr. McMemory.
All right, thank you. So let me, hold on, guys. I need to swear my interpreter in. Mr. Nukumendi on page 8. All right, thank you. Good morning, sir.
Good morning, Your Honor.
You swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
Yes, I do, Judge. My full name is Zachary Shapiro. That's Shapiro for the record.
All right, thank you for being here, Mr. Shapiro. Mr. Nukumendi, good morning, sir.
Mr. Nukamende, buenos días.
The court does find probable cause for touch or strike battery, domestic violence.
El tribunal determina que si hay motivo fundado para este cargo de agresión doméstica por haber tocado o golpeado.
Mr. Linder, first to you.
Your Honor, I'm recommending a $2,500 bond and no victim contact.
Señor Linder, deme su recomendación. Voy a pedir una fianza de $2,500 y prohibirle el contacto con la víctima.
This is based on the level of violence alleged and also that there was a 2-year-old present when this occurred.
Mi recomendación se basa en el nivel de violencia alegado y porque había también un menor de edad de 2 años presente.
Additionally, Mr. Nukumendi was arrested in 2019 for aggravated assault and culpable negligence.
Y también se basa porque en el año 2019 lo arrestaron por un cargo de amenazas con agravantes y por negligencia dolosa.
The charges were dropped but involved the same alleged victims.
Se desecharon esos cargos, pero era la misma víctima presunta en ese caso.
In 2013, he was arrested for false imprisonment, tampering with the victim, and battery.
En el año 2013 también lo arrestaron por encarcelar a una persona ilegalmente, por alterar un testigo y por agresión.
Charges were dropped and involved a different alleged victim.
Esos cargos se desecharon y la presunta víctima era otra persona.
Nothing further, Judge.
Nada más, pues.
Thank you, Mr. Romero.
Gracias, señor Romero.
Judge, speaking with this gentleman, he's been residing here in South Florida, our community, almost his whole entire life for the past 20 years.
Su señoría, este señor ha vivido en nuestra comunidad en el sur de la Florida casi toda su vida por los últimos 20 años.
He works in landscaping, been with the same company for 5 years, gets paid approximately $130 a day.
Él trabaja en jardinería, lleva en la misma compañía unos 5 años y tiene $130 en deudas.
Now, him and the alleged victim do live together. I did advise him the significance of no contact, direct or indirect. He will abide by that order and will be residing with his cousin.
Yo le expliqué que él y la presunta víctima no podrán vivir juntos y que usted emitirá una orden de no contacto directo e indirecto con respecto a la víctima, y él me dijo que puede cumplir y obedecer la orden y vivirá con uno de sus primos.
Judge, this is a misdemeanor offense. From what I heard, Mr. Necomande has a clean record. I'm going to be asking for the court to consider a $1,000 bond on his behalf at this time.
Señoría, este es un delito menor y según lo que escuchamos, el señor Ncamendi no tiene antecedentes penales de ningún tipo, por eso recomendaría yo una fianza de $1,000.
All right, thank you. Based on the level of violence, the allegation that there was a 2-year-old child present in the bed with the listed victim when this allegedly happened, I am going to set bond in the amount of $2,500 as requested by the state. So the conditions of your bond, even while you're in custody, are?
Bueno, gracias. Basado en el nivel de violencia alegado en este caso y también la acusación que había un menor de edad de 2 años presente, voy a fijar la fianza en la recomendación de la Fiscalía de $2,500. Señor, las condiciones de su libertad son las siguientes.
That you cannot have any contact, direct or indirect, with the a listed victim. Do you understand?
Voy a prohibir el contacto con la víctima, ya sea directo o indirecto. ¿Entiende esa orden?
Entiendo.
I understand.
That means not only can you not live with her, you cannot call her, text her, email, social media.
Señor, usted no se le permite ni vivir con ella, llamarla, mandarle mensajes de texto, comunicarse con ella por redes sociales.
Or have a family member or friend send a message to her, or any other means of communication that I have not said.
Tampoco puede comunicarse con ella por medio de otro medio de comunicación que yo no haya mencionado, ni tampoco por medio de un pariente o amigo.
You understand?
¿Entiende eso? I understand.
Also, based on the domestic violence nature, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
También por lo que este caso es de agresión doméstica, voy a prohibir que usted posea armas de fuego y municiones mientras este caso está pendiente. ¿Entiende también?
Entiendo también.
Yes, I understand that as well.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir.
Voy a nombrarle a la Defensoría Pública provisionalmente durante el periodo de pandemia.
When COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on his case?
Cuando concluya el coronavirus, va a tener que solicitar a la Defensoría Pública para que lo sigan representando. ¿Hay algo más pendiente en este caso?
Judge, I don't know if you heard, he plans on retaining private counsel.
No sé si usted escuchó esto, señoría. Él pretende contratar a un abogado privado.
My apologies, I missed that part, so I will retract the provisional appointment of your office.
Le pido disculpas, no lo había escuchado. En este caso voy a retirar el nombramiento provisional de la Defensoría Pública en este caso. Buena suerte, señor.
Do you have her name? Oh, do you have her name? Okay, thank you so much. Thank you. All right, so let's do the other Spanish interpreter cases. Since Mr. Shapiro is here, let's go over to Conti facility.
Good morning. Buenos
Right.
días.
Good morning, sorry, who's the first person here?
Su nombre.
Buenos días, señor. Primera comparecencia.
Dile su nombre.
Jorge Castellanos.
Jorge Castellanos.
Jorge Castellanos.
Okay, thank you. This is Mr. Castellanos on page 3 of the FMN 3040 docket.
Gracias. Este es el señor Castellanos en la lista de casos número 3040.
Mr. Linder has the state file charges.
Señor Linda, la Fiscalía ya formuló cargo.
Not at this time, Your Honor. He is entitled to an ROR. Just requesting that the court keep the no victim contact order in place.
No, su señoría, por eso estamos concediendo que le pueden dar libertad bajo palabra. Lo único que sí solicitaríamos es una orden de no contacto con respecto a la víctima.
All right, Ms. Edgley, does your office have his phone number in their file? Because he is going to be released today.
Bueno, por lo que la Fiscalía no ha formulado cargos, lo van a liberar hoy bajo palabra.
All right, sir, please give your phone number to Ms. Edgley here in the courtroom before I continue.
Señor, por favor, dígale su número de teléfono a la señora Ashley antes de continuar con las órdenes.
Teléfono.
Es de mi familia.
Sí, o 956.
En voz alta, señor, por favor.
954. 954.
Sí.
245. 8330.
Señor, hable en voz alta que no le oímos bien.
954.
Sí.
918. O 6407.
954-918-6407.
No.
All right,
Ya
thank
lo
you.
anoté, gracias.
Sir, you are going to be released on your own recognizance.
Señor, lo van a liberar bajo palabra.
That means that you're going to be released today. However, the condition of your release is still that you cannot have any contact or indirect with a listed victim. Do you understand?
Señor, eso quiere decir que lo van a liberar hoy bajo palabra, pero todas las condiciones permanecen en efecto. Voy a prohibir el contacto de usted con respecto a la víctima, ya sea directo o indirecto. ¿Entiende?
Sí, sí, entiendo.
Yes, I understand.
Please be. Yes, ma'am, go ahead.
Tengo información relevante.
He's not being released, he has an immigration hold, so immigration doesn't.
48 hours.
Señoría, a él no la van a liberar hoy. Tiene una orden de retención de inmigración. Si ellos no lo vienen a recoger en 48 horas, lo liberarían bajo palabra.
All right, sir, so you still have an immigration hold, so that means immigration has 48 hours within which to pick you up. If they do not, then you will be released.
Señor, tiene una orden de retención de las agencias de inmigración. Ellos tienen un plazo de 48 horas para ir a recogerlo a la cárcel. Si no lo recogen, lo liberarían bajo palabra.
So the no victim contact applies even while you're in custody. Do you understand?
La orden de no contacto aplica mientras usted esté preso o en libertad. ¿Entiende eso?
Sí, entiendo.
Yes, I do.
All right, thank you. Who do we have next?
Bueno, gracias. Siguiente.
¿Cómo se llama ese? Correa Caballero.
Correa Caballero. Okay, so he is on page 2. Okay, thank you.
This is another Spanish interpreter case, Your Honor.
Mr. Linder, this is a 3040 motion. Has the state filed charges?
No, Judge, he's entitled to an ROR, just asking that the court keep the no victim contact order in place.
That is gonna be the same.
Your Honor, does this case require an interpreter?
Yes, please go ahead.
Sí, señoría, en este cargo es lo mismo que el caso anterior. No hemos formulado cargos. Vamos a darle libertad bajo palabra. Y señoría, tengo información relevante para usted. Es lo mismo que el caso anterior. Tiene una orden de retención de inmigración.
Okay, sir, so the state has not filed charges yet against you.
Señor, la fiscalía aún no ha formulado cargos en su contra.
That does not mean that they still cannot file charges, but you are going to be released on your own recognizance.
Eso no quiere decir que no tienen el derecho a formular cargos después. Lo van a liberar bajo palabra mientras tanto.
However, the no victim contact, direct or indirect, still applies while your case is pending. Do you understand?
Sin embargo, la orden de no contacto directo o indirecto con respecto a la víctima permanece en vigencia mientras su caso está pendiente. ¿Entiende?
I couldn't hear a response.
Escuché su respuesta, señor.
Sí.
Yes.
There is an immigration hold that's currently on you and it will remain for at least 48 hours.
Las agencias de inmigración han impuesto una orden de detención sobre usted por 48 horas.
If you are not picked up within those next 48 hours, then you will be released, okay?
Si no lo recogen en esas 48 horas de plazo, lo liberarán bajo palabra.
Anything else on his case?
¿Algo más en este caso?
No, Judge.
No.
Do you want a phone number for him? Okay, and if we could get a phone number for him, so Ms. Edgley can have it on file, please.
Voy a nombrar a la Defensoría Pública provisionalmente. Señor, díganos su número de teléfono para que se puedan comunicar con usted.
Hijo, el de mi familia. Usted. Sí.
Señor, hable alta que no lo escuchamos bien, por favor.
4.
Diga.
954.
Sí.
954.
Sí.
880.
¿8 qué?
880.
Hay mucho ruido aquí, señor. Hable en voz alta, por favor.
880.
880.
Sí. 4742.
954-880-4742.
Thank you, sir. Good luck to you.
Listo, gracias, señor.
And the last Spanish interpreter case that we have?
Escobar 1.
All right, Mr. Escobar on page 3 of the FMN 3040 docket. Okay,
El caso del
thank you.
señor Escobar en la página 3, pues tiene la misma condición.
Okay, thank you. Mr. Linder, has the state filed charges?
No,
Gracias,
Judge.
señor Linder. La fiscalía ya formuló cargos en este caso.
No, Judge, he's entitled to an ROR, asking that the no victim contact order remain in place.
No, juez, tiene derecho a libertad bajo palabra. Vamos a pedir que la orden de no contacto con la víctima permanezca en vigencia.
Okay, thank you. All right, sir. The state has not filed charges yet. That does not mean that they cannot still file charges.
Bueno, gracias. Señor, la fiscalía no ha formulado cargos en su caso. Eso no quiere decir que no puedan formular cargos en el futuro.
Your motion for ROR will be granted, but you cannot have any contact with the listed victim, direct or indirect. Do you understand?
Vamos a conceder su petición de libertad bajo palabra. Sin embargo, la orden de no contacto permanece en vigencia. No se le permite comunicarse con esa víctima directa o indirectamente. ¿Entiende, señor? Yes.
And that includes while you're in custody. Understood?
I'm sorry, Judge?
And that includes while you're in custody. No victim contact.
La orden de no contacto aplica mientras usted esté preso o en libertad.
Sir, you have an immigration hold on you, which gives the immigration authorities 48 hours to pick you up.
Señor, usted tiene una orden de retención de inmigración. Es decir, que las agencias de inmigración tienen un plazo de 48 horas para ir a recogerlo a la cárcel.
If they do not pick you up, then you will be released in those 48 hours. Understood?
Si no lo recogen, lo liberarán bajo palabra después de que pasen las 48 horas. ¿Entiendes?
Does he understand?
Señor, ¿entiende?
Sí, está bien.
Yes, that's fine.
All right, please give your phone number to Miss Edgley so she has it on file for you, sir.
Señor, por favor, dígale su número de teléfono a la señora Edgley para que lo ponga en su expediente.
954.
954.
558.
Hable en voz más alta, señor, que hay mucho ruido aquí en la sala y no se le escucha muy bien.
5380.
El número completo, por favor, 954.
558.
Sí. 558.
5380.
5380. Yep. 954-558-5380. Gracias.
All right, thank you. Take care, sir.
Gracias, señor. Cuídese mucho.
All right, Shapiro, have a great day.
My pleasure, Judge. I may have the case number or the arrest numbers or case numbers for the last two.
Can you just, do you mind walking over to Mr. Linder's desk and writing them down? Thank you so much, Mr. Shapiro. No, it's on this second work docket. That's the wrong doc. That's the wrong docket. All right, thank you. Thank you, Mr. Shapiro. All right, we can do the other individuals at Conti, so you guys can go since you only had a couple of people there. Who else do you have?
Montfort Robert.
Montfort. Okay, Mr. Montfort, good morning, sir.
No, ma'am.
Fine, thank you. Mr. Linder, this is a motion for 3040, has the state file charges.
One moment, Your Honor. No, Judge, he is entitled to an ROR, which just asks that the no contact order remain in place.
All right, thank you. All right, so Mr. Montfort, the state has now filed charges, which means you're going to be released on your own recognizance. However, please note that the no victim contact, direct or indirect, is still in play. Do you understand?
Yes, ma'am.
All right, that's a condition of your release. If you violate that condition, it's a potential you could be sitting back in custody. Do you understand?
Yes, ma'am.
All right, please provide your phone number to Ms. Edgley so she has it on file, sir.
61-229-6003.
All right, thank you. Did you get them essentially? The first three digits, please.
561 229 6003.
I don't know. The first digits are a 561.
Yes.
561. Okay, yes, thank you. We missed that. All right, sir, good luck to you.
She had pretrial.
Okay, so Madam Clerk, we need to delete the GPS since he's going to be a straight ROR. So you're just going to be released without a pretrial component. Good luck to you, sir.
Okay, thank you.
Delete trial GPS. Thank you. All right, so who do we have next?
McIntosh.
All right, Mr. McIntosh, good morning, sir.
Yes, ma'am. Good morning.
No problem. All right, Mr. Linder, this is a motion for 3040, has the state file charges.
This is on McIntosh, Your Honor.
Yes, Mr. McIntosh on page 4 of the FMN docket.
Your Honor, the state has not filed an information is entitled to an ROR, which is has the no return order be put in place.
All right, thank you. All right, Mr. McIntosh, the state has not filed an information. That means you are entitled to an ROR. However, please note that a condition of your release is that you cannot go back to the listed incident location. Do you understand?
Right. Yes.
All right. Yes.
She was on pretrial GPS.
All right, and we need to delete the pretrial GPS on this one as well. Ms. Dunbar, please. All right, and please give your phone number to Ms. Edgley so she has it on file, sir.
754 422 5434.
All right, thank you. Did you get that? All right, thank you. Good luck to you, Mr. McIntosh. Do not go back there.
Thank you. Yes, ma'am.
All right, no problem. And I think we have one more person at Conti, and that is Mr. Brown, correct?
Yes, sir. Yes, ma'am.
All right, Mr. Brown, good morning, sir.
Come on.
All right, Mr. Linder, this is another motion, a 3040 motion, has the state file charges.
No, Your Honor, he's entitled to an ROR, which just asks for the no victim contact order remain in place.
All right, thank you. So, Mr. Brown, the state has not filed an information yet. That does not mean that that precludes them from filing an information still. Your motion for ROR will be granted. However, please note a condition of your release is that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am.
All right, if you do contact the victim intentionally, it could be a violation of your release conditions. Do you understand?
Yes, ma'am.
Provide your phone number to Ms. Edgley from the Public Defender's Office so she has it in their court file.
954 707 3787.
All right, thank you. Anything else on Mr. Brown? All right, thank you, sir.
Thank you for your time.
No problem. Take care.
Thank you very much, ma'am.
All right, thank you. Have a good day, guys. All right, so let me grab my stack. Let's start on page 1. All right, page 1, Ms. Mills.
Your Honor.
All right, thank you, Ms. Mills. Good morning, ma'am. The court does find probable cause for touch or strike battery domestic violence. Mr. Linder, first to you, sir.
Judge, I see no history. I'm recommending an ROR to pretrial and no victim contact.
All right, thank you. Ms. Edgley, ma'am.
Judge, that would be acceptable.
All right, and does your office need to be provisionally appointed?
Yes, Judge.
All right, thank you. All right, Ms. Mills, you are going to be released today, but you have to call in the pretrial release before 11 a.m. tomorrow. So if you do know your phone number, please provide it to the clerk now. What's your phone number, Ms. Mills?
754
A little bit louder. We can't hear you.
244-5285.
I couldn't hear that. Could you, Ms. Worrell? You need to speak louder, please.
754 244
5285.
5285.
All right, thank you. All right, ma'am. So you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means that you cannot live with him, call him, text him, email, social media, have a family member or friend contact him for you, or any other means of communication that I have not said. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand? Sorry, was that a yes?
Yes.
All right, we'll also provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on her case?
Yes, Judge, I would be asking for a return order.
All right, ma'am, I will give you a one-time allowance to go to the home with law enforcement. That means that you have to go to the Lauderdale Lakes Police Department with this court order. That will give you a one-time allowance to go back to the home with law enforcement to get your belongings. If you go by the home, you cannot be alone. You cannot be with anybody else other than police, and you can do so one time after you leave the facilities. Do you understand? Sorry, is that a yes?
Yes.
All right, thank you. Anything else? All right, go ahead. Next is Ms. LaHue, and the listed victim is present on the Zoom. All right, Ms. LaHue, good morning, ma'am. The court does make a finding of probable cause for aggravated battery with a deadly weapon, domestic violence. All right, so where is he? All right, sir, so now would be your time to start your video.
Okay, hello.
All right, Mr. Graziano, good morning. You are the listed victim. Are you here to see what happens, or did you want to tell me something?
I would like to speak.
All right, please raise your right hand for me, sir. Do you swear or affirm your right hand?
Oh, sorry, ma'am.
Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and state your name for the record.
My name is Robert Harris Graziano.
All right, sir, you are the listed victim, and you're here without an attorney, and you previously spoke with law enforcement, so I need to advise you anything you say today can be used against you at a later date. Do you understand?
Yes, ma'am.
All right, thank you, sir. What is it that you wanted to tell me?
That all the stuff is just it was a big misunderstanding, and I was drunk that night, and what happened was not true. It was just a big misunderstanding. Lauren's a good woman, and she has a job. She has her daughter misses her family, and yeah, this is a big misunderstanding, and I do not want to press charges.
Okay, thank you, Mr. Leonard. Does the state have any questions for him based on his line of inquiry?
Yes, Your Honor. Mr. Graziano, is it true
Yes,
that
sir.
law enforcement responded to the home on June 28th of this year regarding a domestic related incident?
Yes, sir.
Nothing further, Your Honor.
What are the allegations in the domestic violence incident from 6/28/21, Mr. Linder? Do you know?
I don't know, Your Honor. Just one moment. I'm just checking to see. I don't know if any arrests were even made.
All right, thank you. While he's looking that up, Ms. Edgley, do you have any questions for the listed victim?
Yes, just want to clarify, you said that you were under the influence of alcohol when this incident happened?
I can't hear.
You're muted.
You said that you were under the influence of alcohol at the time that this incident happened?
Yes, I was, not her.
Okay,
Yes.
and you said that it did not happen as the officers reported?
No. It's not true. No, ma'am.
Okay, so she didn't attempt to hit you with a car?
No.
She didn't make contact with you with a vehicle?
Not at all.
And it did not happen once?
No.
It
Not at
didn't
all.
happen a second time?
No, not at all.
Okay. And do you have any interest in having contact with her?
Yes, of course. I mean, she's a good friend, very good friend.
Are you in fear of her?
No, not at all. Not at all.
No further questions, Judge.
Okay, thank you. Mr. Linder, just let me know when you can find that information.
It doesn't look like any arrests is made, Your Honor.
All right, thank you. The concern that I have is that there was a listed independent witness, a neighbor who witnessed her allegedly driving erratically and on the wrong side of the road. Also, that came outside based on Mr. Graziano's fear that he reported. So at this time, I am going to order no victim contact. There needs to be a cooling off period based on these allegations that she allegedly struck him with her car twice. I understand what he's saying today, but there was an independent witness that observed her erratic driving pattern. Mr. Linder, what's the state's recommendation with regards to bond?
Judge, I'm recommending a $5,000 bond. This will now be Ms. LaHue's second arrest this year for domestic violence. She was arrested earlier this year in February for 2 counts of domestic violence battery against different alleged victims. Those charges were dropped, Your Honor. It does look like she has gone through drug court previously. One moment. She successfully completed drug court in 2019 for possession of clonazepam and DUI. 2010 felon possession of cannabis. Nothing further, Judge.
Okay, thank you. Ms. Edgley?
Judge, Ms. LaHoo has been a Broward County resident all of her life. She works for Old Navy and Gap, and she's worked there for approximately 2 years. She doesn't have any serious priors, from what I understand, no history of failures to appear. She cannot afford to post any bond, unfortunately. She's waiting for a reassignment at a different store, and so she currently doesn't have any money to post bond. She lives at her own place. She doesn't share, a residence with the listed victim, so she doesn't have a reason, to have contact with him, as she will be living separately. I'm requesting, Judge, that she be released on pretrial conditions that the court would deem appropriate. Given the fact that she doesn't have any serious priors, ask for standard pretrial release.
All right, thank you. My apologies, Mr. Linder. What was the state?
5,000, Your Honor.
All right, thank you. Based on the allegations, the independent witness, I am going to set bond in the amount of 3,500. You cannot have any contact, direct or indirect, with the listed victim. Mr. Graziano, do you understand?
Yes.
That means you cannot live with him, call him, text him, email, social media, send letters, have a family member or friend send a message to him, or any other means of communication that I have not said. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else?
Okay.
Good luck, to you, ma'am. Good luck to you, Mr. Graziano. Thank you for being here. Next is Ms. Nicholas on page 2.
Judge, she's here, President Maine.
All right, thank you. Good morning, ma'am. The court does find probable cause for battery on a person 65 years of age or older. Mr. Linder, first to you.
Judge, I'm recommending a $3,500 bond. Should she post bond, pretrial release, random testing, no victim contact. She was arrested in 2018 for domestic violence battery against a different alleged victim. That was dropped. She had a trespass in 2016. Nothing further.
Okay, thank you. Mr. Romero.
Judge, Ms. Nicholas has been residing here in South Florida for the past 5 years. Now, she lives separate and apart from the alleged victim. She resides in Miami with her husband. Ms. Nicholas is not working. She is on disability. As I heard, she has no prior violent offenses, Judge. She does not know if her husband will financially be able to post this monetary bond. Judge, considering her strong ties, her lack of any serious criminal history, Judge, we were going to be asking for the court to consider releasing Ms. Nicholas on pretrial release. Also, we're going to be asking to be provisionally appointed on her case.
All right, thank you. Based on the level of violence, as well as the allegation that the listed victim had ovarian cancer allegedly where she was kicked, I'm not going to accept that request. What is your monetary request?
Based on this previous state of reasons, I'd be asking them for a $1,000 bond.
All right, thank you. All right, ma'am, I am going to set your bond in the amount of $2,000. Once you post bond, you're going to be supervised by pretrial release. So please give your phone number to pretrial before I continue with my orders.
Judge, I inquired as to her phone number. She did not have her phone number. Basically, then I did advise her when she calls into pretrial that she would have to go ahead and give them some sort of contact information when she calls in.
All right, not a problem. Thank you. So, ma'am, once you post your bond, you have to call into pretrial release before 11 a.m. the next business day, and you'll have to provide them not only with a phone number, but an address where they can find you. Do you understand?
You understand?
Did she say yes?
Yes.
All right, ma'am. You also cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means that not only can you not go by where she lives, where she works, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand? You have to speak up, please.
Yes, I heard you.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand? And you cannot use any drugs or alcohol while your case is pending. Do you understand?
Yes.
You are going to be randomly screened for drugs and alcohol at least 2 times per week. Do you understand? 2 times.
Thank you.
All right, if there's an initial screen for drugs, that'll be your baseline. Upon subsequent or later testing, if your levels don't go down, but instead stay the same, get higher, or there's a new drug or any sort of alcohol introduced, you could be violated. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply to make sure they keep representing you. Anything else on her case?
That's it.
All right, good luck to you, ma'am. Next on page 3 is Ms. DeShoosh. Ma'am, good morning. The court does find probable cause for trespassing. It's at a Chevron gas station. Mr. Linder, do you have an offer if she wishes to resolve?
Withhold court cost or ROR, no return in either situation.
Does she have any priors?
I didn't see anything.
Okay, thank you. So Ms. Edgley, it appears she may be eligible for a pretrial version program. What does your client wish to do?
Yes, Judge, because she has no priors, we are requesting that she be released on her own recognizance.
All right, not a problem. So Ms. DeShoosh, you are going to be released on your own recognizance. That means that you're going to get out today, but you cannot return to the Chevron gas station and the police reports. Do you understand?
Yes, ma'am.
All right, and Ms. Edgley, does your office need to be appointed?
Yes, Judge.
All right, thank you. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply, okay? Good luck to you, Ms. DeShoosh. Please be in touch with your attorney. Okay, next is Ms. Walsh on page 3.
Here present at main, Judge.
All right, thank you. Ms. Walsh, good morning, ma'am.
Good morning, Your Honor.
The court does find probable cause for trespassing at an 8+ storage and resisting an officer without violence. I do note some mental health concerns based on the statements and the police reports. Mr. Linder, does the state have a recommendation? I don't believe I would be willing to take a plea today based on the allegations.
I'd be recommending a transfer to MI, Your Honor.
All right, thank you, Mr. Romero. Would you have any objection to transferring her to mental health court based on the statements where she allegedly yelled at officers to kill her multiple times?
One moment, Judge. Let me speak to her.
Okay, no problem.
What is it gonna eat? 10 o'clock.
Judge, I did speak with Ms. Walsh. I did advise her. I know when we spoke earlier, she did advise me as far as the location. She did want me to ask the court to consider resolving her case for time served. I did advise her at this time. There's no offer from the state. Judge, I would not be objecting as far as this case being transferred to Judge Lerner Wren. However, in speaking with Ms. Walsh, she's unemployed, she's homeless. We are asking on her behalf to be considered to be released ROR.
All right, thank you. I am going to transfer this case to Judge Lerner Wren's division. Ma'am, you cannot return to the 8+ storage. Do you understand?
Yes, ma'am. Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you, okay? So Mr. Romero, I would consider releasing her to pretrial release with the condition that she receive a mental health evaluation within 3 weeks, or otherwise the bond in place.
Judge, one moment, let me make sure.
It would just be over the state's objection, just since Judge Lerner Wren has requested formally that bonds be kept in place on cases transferred to her.
All right, thank you, Mr. Linder.
Judge, I did speak to Ms. Walsh at this time. No objection with that condition, Judge.
Ma'am, you're going to be released a pretrial release, which means you're going to get out today, but you have to call in before 11 a.m. tomorrow. Please provide your phone number to pretrial.
No, I don't have a phone. They stole my phone. Okay. I don't have a phone, Your Honor.
I can't release her to pretrial, Mr. Romero. I'm going to leave the bond in place, okay? She can go before Judge Lerner Wren.
Judge, I didn't hear the court.
She said, I said she doesn't have a phone. I'm not going to release her. So I'm going to leave the bond in place and Judge Lerner Wren can address it then, okay?
If that's the court's ruling, Judge.
All right, not a problem. Ms. Walsh, good luck to you. You'll see Judge Lerner Wren soon and she'll address those issues with you. We're going to get you a doctor to talk to you, okay?
Appreciate it.
Judge, in that case, I'm going to be asking, obviously, she's in custody. I'm assuming the court's not going to be imposing that condition as far as a mental health evaluation. So, but I'm going to be requesting a mental health screening.
Okay, not a problem. I will sign that mental health screen based on the reasons I put forth earlier. Thank you. And again, doctor to talk to. Good luck to you, ma'am. Next, Ms.
And
Holmes
Judge-
on page 4.
Judge, if I may, just before we move on, I would be requesting the court would still release her under pretrial release. Just because she doesn't have a phone doesn't mean she's not able to get in touch with pretrial release. Sometimes people live in poverty and they don't have their own phone. It sounds like she said she had one, but it was taken from her. And so I'd ask the court to continue to go back and decide to release her on her own recognizance to pretrial release with an order to call pretrial.
Okay, I've already ruled. Thank you, ma'am. All right, next is Ms. Holmes on page 4. All right, Ms. Holmes, good morning. The court does find probable cause for your KPS for petty theft. Mr. Linder, does the state have an offer she wishes to resolve?
Yes, Judge. Adjudication time served, no return to the Walmart at 3306 North University Drive in Sunrise.
All right, thank you, Ms. Edgley.
Yes, Judge, and she will accept that offer.
All right, thank you. So ma'am, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. You can put your hand down and please state your name for the record.
Olivia Holmes.
All right, Ms. Holmes, it's my understanding that you wish to resolve this petty theft charge.
Yes, ma'am.
All right, do you understand the charge against you? You have to say it out loud, sorry.
Yes, ma'am.
All right, do you understand everything we've discussed today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of alcohol or drugs?
No, ma'am.
All right, do you need more time to speak to your attorney?
No.
And have you ever been treated for a mental or emotional illness?
Yes.
And is there anything about the illness to you that impacts your ability to accept this plea?
No, ma'am.
All right, and I'm not asking if you're a citizen, I'm just advising you. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
I'm a citizen.
All right, and I also must advise you that upon a third arrest after 2 convictions for petty theft may result in you being charged with a felony and or receiving jail or prison time. Do you understand?
Yes, ma'am.
All right, knowing all of that, how do you wish to plead, ma'am? Guilty or no contest?
No contest.
Ma'am, I accept your no contest plea is freely, voluntarily, knowingly given. I'll sentence you to an adjudication time served with an order of no return to the Walmart in the police reports. Ms. Edge, how much time does she have to pay?
Judge, we request that it would be converted to a civil lien.
All right, not a problem. And I'll convert your court cost of prosecution, a PD application fee to a civil lien. What that means, Ms. Holmes, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off. Good luck to you, Ms. Holmes. If nothing else is holding you, you should be released today, ma'am.
Thank you, Judge.
Take care, ma'am. Feel better. All right, next on page 5, we have no paperwork for all of those people. So next on page 6 is Ms. Shepherd.
Afterwards, the jail is requesting if you could take the gentleman out of order. I believe Patrick Wells, after you're done with this client.
Okay, no problem. Thank you so much. All right, Ms. Shepherd, good morning, ma'am. The court does find probable cause for possession of fentanyl and possession of cocaine. Mr. Linder, first to you.
One moment here. Your Honor, I'm asking that the court keep the bond in place. Shepherd is currently out on bond for possession of cocaine in 2019. Moment. She also resolved a prostitution last year, paraphernalia 2019, trespass 2018, prostitution 2017. Nothing further, Judge.
All right, thank you. Ms. Edgley.
Judge, what I can tell you is that Ms. Shepherd has been a Broward County resident from 2016. She's currently not working. She does live in Pompano Beach. She has a home to return to when she's released, if the court exercises the court's discretion to release her onto pretrial release. Unfortunately, she can't afford any bond, Judge. She has no serious criminal history, Judge, no history of a failure to appear. And so I'd request that the court would ROR her to stand her pretrial release.
All right, thank you. Seeing as she paid bond in the other case, I'm going to give her an opportunity for pretrial release. I understand it's over the state's objection. Ms. Shepherd, you're going to be released today to pretrial release. That means that you have to call in tomorrow before 11 a.m. Please give your number to pretrial before I continue with my orders.
Give them your phone number, speak loudly.
954. Can you hear me?
I can, yes.
954-449-8091.
Hold on, I missed the second set of three numbers.
954-479.
954-479.
8091.
8091, did you get that? All right, ma'am, you cannot use any drugs and you can't use any alcohol while your case is pending. Do you understand? Sorry?
Yes.
Because you are going to be randomly screened for drugs and alcohol at least one time per week, based on this now being a second alleged drug offense that you have pending. Do you understand? All right, we'll provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply to make sure that they keep representing you, okay? All right, Ms. Shepherd, good luck to you. You should be released today and you're going to be, have to call in tomorrow. All right, what was that person in the page, Mr. Romero?
Sir Patrick Wells on page 10, Mr. Wells. It's an MO judge, and I believe Usa.
Okay, thank you. And Mr. Plain is here for his case. All right, Mr. Wells, good morning, sir. Are you feeling okay? Mr. Wells, it's my understanding you're not feeling well, but are you feeling well enough to go forward on this case? Sorry, I can't hear you.
Yes.
All right, Mr. Wells. So I do find probable cause for a KPS for trespass. Okay, thank you. So it's my understanding that you wish to resolve this case today, correct, Mr. Wells?
Correct.
Okay, thank you. Please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down and please state your name for the record.
Wells.
All right, Mr. Wells, I know that you're not feeling well, but are you feeling well enough to go forward with this plea today?
Yes.
Okay, and you'll let me know if that changes, correct?
Yes.
All right, do you wish to resolve your case?
Yes.
Do you understand the charge against you? Is that a yes? Sorry.
Yes.
And is anyone forcing you to resolve your case?
No.
Are you under the influence of alcohol or drugs?
No.
All right, have you ever been treated for a mental or emotional illness, sir? Sorry, was that?
No.
You understand you have a right to go to trial, but you're giving that up by accepting the court's offer?
Yes.
Do you need more time to speak to your attorney? I'm not asking if you're a citizen. I just have to advise you. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes.
All right, and how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, I accept your no contest plea is freely, voluntarily, knowingly given. I do find there's a factual basis for your plea. I am going to adjudicate you with a credit for time served in an order of no return. How much time does he need to pay, Mr. Plant?
180 days, Your Honor.
You can do 6 months, a year, or convert it to civil lien.
Or a year, Your Honor.
All right, so I'll give you 1 year to pay your court costs, Mr. Wells. And if there's nothing else holding you, you should be released today. Good luck to you, sir. Feel better.
Thank you, Judge. Good luck, sir.
All right, no problem. All right, so back to our docket. I'll get to your other cases. I promise, Mr. Plant. Thank you for your patience.
Yes, Judge, of course.
All right, next on page 7, Ms. Davidson has waived her presence. All right, thank you. The court does find probable cause for her out-of-state hold from Texas. She's going to be held no bond and will have to go before extradition court next Tuesday. If there's nothing else on her case, we're concluded. So that brings us to page 8. Mr. Baco Giannis.
Good morning, Your Honor.
All right, good morning, sir. The court does find probable cause for battery, cause bodily harm, or disability. Mr. Linder, first to you, sir.
Judge, I'm recommending a $1,500 bond, no victim contact. It's based on the level of violence. Also, he was arrested in 2016 for domestic violence battery against a different alleged victim. Charge was dropped. Nothing further.
All right, thank you, Mr. Romero.
Judge, I spoke to this gentleman this morning. He's been residing in our community for the past 10 years. He's employed for a tech company, working there for the past year. Now, him and his wife do reside together, but my understanding is she's going to be leaving town, so there's not going to be any issue as far as contact. But in the meantime, he does know the significance as far as no contact, and he'll be finding a separate place where to reside. Judge, considering his strong ties, his lack of criminal history, we're going to be recommending or asking the court to consider releasing him ROR to pretrial, and also provisionally appointing my office, Judge.
All right, thank you. Based on the level of violence and the allegation that the victim was in the hospital as a result of her injuries, that is not an appropriate request. I am going to set bond in the amount of $1,000. Once you put bond, you're going to be supervised by pretrial release based on the allegations that you both were out drinking prior to this incident happening. So please provide your number to pretrial before I continue with my orders.
786-457-2967.
Did you get that?
What's that for, Your Honor?
Ms. Worrell? Time, sir. He needs to repeat it, please. Ms. Worrell from pretrial didn't get it.
Judge, it's 786-457-2967.
All right, sir. The purpose of you giving that phone number is because you're going to be supervised by pretrial release, as I just said, based on the allegations that you and the alleged victim were drinking prior to this alleged incident happening. So that means that you need to report in a pretrial release by the next business day before 11 a.m. Once you post your bond. Do you understand?
No problem.
All right. You also cannot use any drugs and you cannot use any alcohol while your case is pending. Do you understand?
Sure.
And you're going to be randomly screened based on the level of violence at least one time per week while your case is pending. Do you understand?
Yes.
All right, Mr. Romero, does your office need to be appointed?
Yes, Judge.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on his case? Okay, thank you. And the intake is via telephone, not in person yet. Once it does change to in person, they'll let you know, sir.
Thank you, Your Honor. So you.
Good luck to you. All right, next is Mr. Gilbert on page 8.
He's approaching Judge Maine.
Hi, Mr. Gilbert. Good morning.
Morning.
Court does find probable cause for a violation of injunction for protection domestic violence in case number 213711MM10A. I am going to revoke your bond. You're going to be held no bond based on you violating intentionally this court's order on 6/25, advising you that you could not have any contact, direct or indirect, with the listed victim. Based on that, on the new law, I am going to set bond at $10,000 with pretrial release level 1 with a GPS. No contact means no contact, Mr. Gilbert. These allegations were that you were in the same hotel room with the listed victim and you were allegedly beating her. I don't know how many ways I can say no contact, but I already advised you that you could not have any contact with her. And I already explained the means and methods that you could not have any contact with her, sir. So that is why I'm setting bond at $10,000 on the new law, pretrial release level 1, strict house lockdown. I'm revoking your bond on the underlying case and pretrial's request as well on the same offense.
Okay, and just to let the court know, he was out on a $2,500 bond with pretrial GPS number 2.
Right.
At the time of this new offense, so you're gonna no bond him on the revocation?
I am. I did a no bond on the revocation. It's on the new law that I said $10,000 pretrial release level 1 and no victim contact, Mr. Gilbert. I know that I already explained the ways of no victim contact, sir. I know that I explained no calls, emails, text messages, social media, letters. I explained any other means of communication. This was just within the last week or two, sir.
And on that, hotel, if he was staying in a hotel, that might have been the address that he was released out in that location.
Judge, I believe he was actually ROR'd to pretrial by Judge McHugh on the 29th.
I did see that I ordered a pretrial with a GPS monitor and Judge McHugh removed the monitor requirement.
Yeah, I was just bringing it up because I don't think he had to give a specific address.
I saw he didn't have to give an address, but now he does based on these allegations and the fact that I have explained explicitly what no contact means. No contact even means while you're in custody. You cannot call her, you cannot send letters, you cannot have a family member or friend send a message to her, any other means of communication, no carrier pigeons, no SOS signal, nothing. Do you understand? I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. All right, good luck to you, sir.
Can you go ahead and repeat?
It is on page 9.
No, the case number that you revoked his release on.
Yes, sir, it's 213711MM10A. You cannot possess firearms, weapons, or ammunition while your case is pending as well, Mr. Gilbert. I know I already told you that last week, but it still applies.
Yes, ma'am.
All right, can I call Mr. Hernandez, please? A lot of echo. All right, Mr. Hernandez, good morning. The court does find probable cause for battery, second or subsequent offense, domestic violence. Mr. Linder, was that battery arrest an actual conviction?
One moment, Your Honor. Your Honor, I'm showing he had a battery in 2012 that he was convicted on, sentenced to 168 days.
2012 battery, and what else?
Your Honor, I'm recommending a $5,000 bond, pretrial release, random testing, no victim contact. Based on the allegation from the victim that there's been prior violence in the relationship. Also, 2018, aggravated assault with a deadly weapon involved a different alleged victim. The battery I mentioned, that was also against a different alleged victim. 2012, fleeing and eluding, 3-year state prison. 2012, aggravated stalking, and 2 counts of a violation of a domestic violence injunction, 3-year state prison. 2010, he was arrested for domestic violence, battery by strangulation, false imprisonment, and battery. Charges were dropped. 2009, 2 counts of dealing in stolen property and grand theft, just under 17 months state prison. 2008, shooting at or throwing a deadly missile, felony criminal mischief, resisting without violence. He violated probation and was sentenced to just under 17 months state prison. Lastly, there was an arrest for battery in 2008, Judge, and that was dropped. Nothing further.
Okay, thank you, Mr. Romero.
Judge, I spoke Mr. Hernandez. He had a lot of questions. He was potentially could be filed as a felony. I did my best to explain to him. I believe he understands why. Having said that, Judge, that doesn't change the circumstance. My understanding is he's not working. He has no one to help post his monetary bond. Judge has been here his whole life. He will abide by the court's no contact order, direct or indirect. However, like I said, he's not in a position to post his own bond, nor anybody else. So at this time, we're going to be asking to be provisionally appointed, and we're asking for the court to consider releasing him or award pre-trial.
All right, thank you. Based on the allegations as well as the listed victims' alleged statement to police that there was a history of DV, I am not going to do that. I will, however, set bond in the amount of $3,000. Once you post your bond, sir, you're going to be supervised by pretrial release. So please give your phone number to pretrial before I continue with my orders.
479 7944.
We can't hear him.
479
Did you get that, Ms. Worrell?
I believe you said 954-479-7944.
Is that correct?
It is 954-479-7944.
All right, thank you. All right, sir. So after you post your bond, you have to report to pretrial release by calling in before 11 a.m. the next business day. Do you understand?
Yes.
All right, you also cannot use any drugs or alcohol while your case is pending. Do you understand?
Yes.
And you're going to be randomly screened for alcohol and drugs at least 2 times per week based on these allegations and level of violence. Do you understand?
Yes.
You cannot have any contact with the listed victim, meaning you cannot live with her, call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes. I have a question.
Hold on 1 minute, but do you understand?
Yes.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand? I now provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Mr. Hernandez, before you say anything, I do need to advise you of a Fifth Amendment right to remain silent. Everything you're saying is being recorded and can be used against you, so do not talk about the facts of your case. Are you sure there is something you wanted to say?
I want to ask a question. If I'm living at this residence and
Don't talk about the facts.
no, I'm not. I'm living at this residence that supposedly I can't go have contact with, and I get released. You have to have an address to be on pretrial release, correct?
It's standard pretrial. You have to give them an address or a location where they can find you, sir. It's not a monitor. It's a standard.
I don't have nowhere else to go. If it's not a requirement on standard pretrial, unless the court orders you, you do not have to have a residence. Right.
But do you understand? You cannot live with the listed victim, sir.
Yeah. That's the only person I've ever had to live with.
Okay, well, you can't go back there. If you go there and you intentionally violate these court's orders, I will revoke your pretrial. All right, good luck to you, Mr. Hernandez. All right, next is Mr. Brown on page 9. All right, Mr. Brown, good morning.
Hi, good morning, Judge.
The court does find probable cause for domestic battery by strangulation and battery caused bodily harm, domestic violence. Mr. Linder, first to you.
Judge, the only prior I see is a 2003 DUI. Based on the level of violence alleged in the probable cause affidavit, I'm recommending a $10,000 bond on 1, 1,000 on 2, no victim contact.
All right, thank you, Mr. Romero.
Judge, he's been living in South Florida for the past 27 years. He's working at Comcast, worked there for the past 6 years. He does live with the alleged victim, but he has other family members that he can turn to for help in order to stay away from the alleged victim. As you heard, he's not a convicted felon. He's a registered voter, has very, very strong ties to the community. He will be coming back to court. He's not going to be able to afford a $10,000 bond. We're going to be requesting a $3,500 bond on Mr. Brown's behalf. No objection to the $1,000 bond on count 2. And we're going to be asking to be provisionally appointed on Mr. Brown's behalf, Judge.
All right, thank you. On count 1, I'll set bond at $7,500. Count 2, $1,000. Sir, the conditions of your bond are that you cannot have any contact, direct or indirect, with the listed victim, and that includes while you are in custody. Do you understand?
Yes, ma'am.
That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, or have a family member or friend send a message to her, but any other means of communication that I have not said. Do you understand?
Understood.
All right, and on count 2, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Do you understand?
I understand.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case?
Yes, Judge, a property order.
All right, I will sign that property order.
Thank you.
Thank you, sir. All right, next on page 9 is Mr. Austin.
Austin is approaching here.
All right, thank you, Mr. Austin. Good morning, sir.
Good morning, ma'am.
Find probable cause for battery, caused bodily harm, dating violence, and resisting an officer with violence. Mr. Linder, first to you, sir.
Judge, recommending a $1,000 bond on each count, no victim contact. His priors, out of Dade County, he was arrested for battery and criminal mischief in 2018. Charges were dropped. 2004, carrying concealed firearm. 3 counts of battery on a law enforcement officer, 1 count of resisting with violence. 2003, 2 counts of possession of cocaine with intent to sell or distribute. Nothing further.
Okay, thank you, Mr. Romero.
As I said, Judge, no objection.
All right, sir, on each of these counts, I am going to set bond at $1,000. The conditions of your bond is that you cannot have any contact, direct or indirect, with the listed victim, even while you're in custody. Do you understand?
Yes, ma'am.
That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, or have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes, ma'am.
And Mr. Romero, I'm sorry if I missed it. Did you say you needed to be appointed?
Oh, I apologize. I never asked, but yes, we're going to be asking to be provisionally.
All right, not a problem, sir. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case?
One further thing, Judge. I know him and the alleged victim were living together. He has his belongings, personal belongings there. He's asking to go back one time with law enforcement to retrieve his personal belongings.
All right, sir, I will give you a one-time allowance with police. It looks like it's Pembroke Park. You have to go to that police station with this court order in order to have them send a police escort with you to the homes. So one time after court to get your belongings. If you go there without police escort, you could be in violation of this court's order, or if you contact the victim beforehand to let her know you're coming, you could be in violation of this court's order. The only way that you can go by the home one time after court is with a police escort for the Pembroke Park. Do you understand? All right, good luck to you, Mr. Austin. All right, next is Mr. Frazier on page 10, whose refusal that there was no legal reason why we could not proceed. All right, thank you. The court does find probable cause for resisting without violence. I am going to leave the bond in place and I'll provisionally appoint the public defender's office to represent him. Anything else in Mr. Frazier's case?
No.
All right, thank you. Next is Mr. Joseph on page 10.
With me.
All right, Mr. Joseph, good morning, sir. The court does find probable cause. Count 1, driving under the influence of alcohol or drugs, first offense. Count 2, driving under the influence with a balance or breath of over 0.15. Count 3, driving under the influence with damage to property or person of another. Count 4, accident, unattended automobile property without leaving ID. Mr. Linder, first to you.
Your Honor, while I see no history, I would know count 2 is supposed to be $1,000, not supposed to be $1,000. I'd be recommending an ROR on count 1, 1,000 on 2 and 3. Should he pose bond, pre-trial release of random testing.
Okay, thank you. Mr. Romero, sir.
Judge, Mr. Joseph been here his whole entire life. He's 21 years old. At this time, he's actively looking for employment. He hasn't been successful. He lives in North Miami with his mom and sister. Judge, as from what I heard from the state, he has a clean record. We're not going to be objecting to pretrial with the special conditions the state has asked for, but we're requesting, based on his clean record, for the court to impose no monetary bond. We're asking to be provisionally appointed on his case.
All right, thank you. Based on the allegations that this was a crash and that he allegedly fled on foot and a witness had to track him down and inform police where he was, I'm not going to do that. However, on count 1, I will ROR him on the simple DUI. On counts 2 and 3, though, I will set bond at $1,000. Once you post bond, sir, you're going to be supervised by pretrial release. So please give your phone number to pretrial before I continue with my orders.
786 558 0328.
Did you get that, Ms. Worrell?
He said 0328.
0328 was,
Yes, ma'am.
okay, yeah. All right. So after you post your bond, you have to call into pretrial before 11 a.m. the next day. Do you understand? All right, and you cannot use any drugs and you cannot use any alcohol while your case is pending, and you are going to be randomly screened for drugs and alcohol while your case is pending. Do you understand?
Yes, I understand.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Joseph. Once COVID is over, sir, you will need to reapply to make sure that they keep representing you. Anything else on his case? Yep, regular randoms. All right, thank you. Good luck to you, sir.
Here's his phone and property. I'm asking for a phone order.
Okay, not a problem. I will sign that phone order. All right, good luck to you, Mr. Joseph. All right, next is Mr. Valdez on page 10. Thank you. Do you know, I didn't see this on the docket. Can you tell me where this is? I didn't see this on the docket. Thank you. All right, Mr. Valdez, good morning, sir. Oh, okay, thank you. Oh, okay. All right, thank you. All right, Mr. Valdez, good morning. The court does find probable cause for trespassing. Mr. Linder, this is at a Sunoco gas station. Does the state have an offer if he wishes to resolve?
If he wishes to resolve, would be an adjudication, time served, no return.
Judge, speaking, Mr. Valdez, that's the first thing he advised me this morning. You wish to resolve this with the time served in exchange for his no contest plea.
All right, thank you so much. Please, sir, Mr. Valdez, raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth, sir?
Without the truth, nothing but the truth, sir.
All right, thank you. You can put your hand down and please state your name for the record.
My name is George Valdez.
All right, sir, it's my understanding that you wish to resolve your trespass case today, correct?
Yes.
And do you understand the charge against you?
Yes.
And do you understand everything we've discussed here today?
Yes. He explained to me I cannot go back to the place that I was with the trespassing. I didn't know I had the trespassing. They never nobody told me that.
Okay, but you got it. That's exactly what's going to happen today. Is anyone forcing you to resolve this case?
Yeah, I'm not going back there. Never again.
Is anyone making you or forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs, sir?
No.
Do you need more time to speak to your attorney?
No, sir.
Okay, and do you understand you have a right to go to trial and fight this case, but you're giving up that right forever by accepting this plea?
Yes, yes.
And have you ever been treated for mental or emotional illness?
No,
Okay, and I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
now you understand that.
All right, and how do you wish to plead? Guilty or no contest?
No,
All right, sir, I accept your no contest plea is freely, voluntarily, knowingly given, and I do find that there's a factual basis to accept this plea. I'll adjudicate you, sentence you to time served with an order of no return to the Sunoco gas station. And Mr. Romero, how much time does he need?
1 year, Judge.
All right, I'll give you 1 year to pay the court cost of prosecution, PD application fee. Good luck to you, sir. If there's nothing else holding you, you should be released today.
okay, thank you very much.
Good luck.
Of course, take care. All right, next is Mr. Petit Frere on page 10.
Yes, Judge Elaine.
All right, sir, good morning. The court does find probable cause for touch or strike battery. Mr. Linder, first to you, sir.
Moment, Judge. Your Honor, I'm recommending a $2,000 bond, no victim contact, no return. First, I would note the strength of the evidence. There was a video of the incident. Additionally, Mr. Petit Frere faces the possibility that this charge could be upfiled through a felony battery. He had 2 separate batteries in 2018, resisting without violence in 2019, resisting with violence in 2018. Nothing further, Judge.
All right, thank you. Mr. Romero.
Judge, Mr. Petit Frere has been residing here in South Florida his whole entire life. He just got a job. He's working, doing basically in a boat lift company at the marina. He gets paid daily, anywhere from $100 to $150 a day. That job is still available to him if he gets released and he doesn't miss any more days of work. He lives in Lauderhill with his mother. Judge, he's asking at this time on this misdemeanor offense that the court would consider releasing him on our order pre-trial, and we're going to be asking to be provisionally appointed on his case, Judge.
All right, thank you. Based on the alleged level of violence, as well as the 2 prior separate battery convictions, as Mr. Linder advised him, he could be charged with a felony battery based on priors. I will, however, leave the bond in place at $1,000. Sir, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
All right.
Do you understand?
Yes, ma'am.
You may not know who he is. You cannot call him, text him, email, social media, send letters, or have a family member or friend send a message to him for you. Understood? You also cannot return to the advanced auto parts mentioned in the police reports. Do you understand?
Yes, ma'am.
Sorry, is that a yes?
Yes, ma'am. Yes.
Okay, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Mr. Petit Frere, once COVID is over, you'll need to reapply to make sure that they keep representing you. Was there anything else on his case?
Property order, Judge.
Okay, I will sign that property order. Good luck to you, sir. Let me just write that on here and slid it over too soon. All right, thank you. Next on page 11 is Mr. Clark is a medical reset. So let me slide this over.
No.
Okay, next is Mr. Small on page 11.
Sir, ma'am.
All right, thank you, Mr. Small. Good morning, sir.
Good morning.
The court does find probable cause for trespassing at alleged someone's home, so I can't imagine the state has an offer. Mr. Linder, what's the state's recommendation and any priors?
Judge, I'm recommending an ROR to pretrial and no return. His history includes 2012 strong-arm robbery, 90-month state prison as a habitual offender, 2010 attempted burglary of a dwelling and grand theft, 2 years state prison as a habitual offender, grand theft auto 07 VOP 2 years, 06 burglary of a dwelling VOP 2 years state prison.
Okay, thank you, Mr. Romero.
Judge, I was just explaining to Mr. Small, there is no plea from the state. So at this time, no objection to having Mr. Small released to pretrial. I was advising him as far as some of the conditions, and he's at this time prepared to give the court his phone number.
All right, thank you. So does your office need to be appointed?
Yes, Judge, based on Mr. Small's financial research, I'm going to be provisionally appointed.
All right, thank you. Mr. Small, you're going to be released today, but you cannot go back to the listed property. Do you understand?
Yes.
All right, please give your phone number to pretrial so they have it on file.
561-341-1999.
All right, thank you. Ms. Worrell, did you get that?
561341.
She needs the last four.
1999.
1999. All right, thank you. You have to call in tomorrow morning before 11 a.m. Do you understand? All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply. Is there anything else in his case that we need to address?
Nothing else, Judge.
All right, good luck to you, sir. Next is Mr. Kraft on page 11.
Mr. Kraft is here at Main, Judge.
All right, thank you. All right, and Mr. Plan is here in the courtroom as well for one of his capiases. Good morning, sir. The court does find probable cause for your capias for petty theft and capias for soliciting or panhandling. Mr. Linder, does the state have an offer on count one?
It'd be a withhold court cost, no return to the target at 5800 South University Drive in Dayton.
City's offer to adjudicate.
Okay, so it'll be a withhold court cost on count one, adjudication time served on count two. He doesn't want to plea open on count two, Mr. Plans?
We'll plea open, yes, Your Honor, plea open.
Okay, so I'll offer a withholding court costs on count two, the solicitation. All right, so Mr. Kraft, please raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down and please state your name for the record.
Thomas Kraft.
All right, Mr. Kraft, it's my understanding that you wish to resolve both of your cases today, correct? All right, and understand the charges against you on both of these cases.
Yes, ma'am.
Is anyone forcing you to resolve either of these cases? Are you under the influence of alcohol or drugs, sir? Couldn't hear you.
No, ma'am.
All right, and do you need more time to speak to either of your attorneys?
No, ma'am.
And do you understand you have a right to go to trial and fight each of these cases, but you're giving up that right forever by accepting the state's offer and the court's offer?
Yes, ma'am.
Sorry, is that a yes?
Yes, ma'am.
All right, and have you ever been treated for a mental or emotional illness, sir?
No, ma'am.
All right, and I'm not asking if you're a citizen, I just have to advise you like I advise everybody that takes a plea. Do you understand that if you're not a United States citizen, that accepting this plea shall subject you to deportation proceedings?
Yes, ma'am.
And I also must advise you with regards to the petty theft that upon a third arrest after 2 convictions for petty theft, you may be charged with a felony and or be sentenced to jail or prison time. Do you understand?
Ma'am.
And knowing all of that, how do you wish to plead to each of these cases, guilty or no contest?
Contest.
All right, so accept your no contest pleas is freely, voluntarily, and knowingly given. I'll sentence you to withhold of adjudication and court costs and an order of no return on the state case to the target referenced in the police reports. And sir, how much time does he need to pay?
In speaking to Mr. Kraft, considering his financial resources, he cannot at this time afford to pay anything. We're asking for a civil lien.
All right, I'll convert all court costs to a civil lien. What that means, Mr. Kraft, is a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay those off. Good luck to you, sir. I also am finding that there's a factual basis for each of these pleas. Good luck to you, Mr. Kraft. If nothing else is holding you, you should be released today. Okay, I'll sign.
Thank you, Judge. Have a good day.
All right, next is Mr. Danny on page 12, who's a medical reset. With on both of them, if you want to write counts 1 and 2, so it's not confusing. All right, thank you. All right, so next on page 13 is Mr. Wells.
Mr. Wells is here present.
All right, Mr. Wells, good morning. The court does find probable cause for battery on an officer, count 2, criminal mischief, $200, but under $1,000 first offense. Mr. Lynn, first to you, sir.
Recommending $1,000 bond on that, Leo, Your Honor. It would appear that Mr. Wells does not have ties to the community.
All right, thank you. I saw that. Mr. Romero, do you have any ties for me?
Judge, at this time, no objection to the state's recommendation of $1,000, but considering his financial resource, we're going to be asking to be provisionally appointed on his case. Also, my understanding, Judge, he is here temporarily seeking some sort of medical advice. He is planning on returning back to Philadelphia, Judge.
All right, thank you. So you need me to put in the order that he can return to Pennsylvania?
Correct, Judge.
All right, thank you. All right, so I will set bond on count 1 at $1,000, sir, and I will also put in this these findings that you can reside in Pennsylvania. And does your office need to be appointed? I'm sorry if I missed that.
If our office can be appointed, I was explaining to Mr. Wells that it's going to be to his benefit as soon as he gets back to call and make an appointment with the signed public defender.
All All right, thank you. So I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Wells. Once COVID is over, you'll need to reapply to make sure they keep representing you. I've already put in here that you can reside in Pennsylvania, so there was nothing holding you up and you can go back. Good luck to you, Mr. Wells. All right, Mr. Plant, are you still here? Mr. Bruzes on page 5, there was no paperwork, so he'll probably be on tomorrow's docket. I was just advising you.
Oh, yes, I'll try to resolve it tomorrow, since it's the only thing holding me in.
Okay. All right, so that, I just wanted to make sure you knew that you didn't have anything else on the docket.
No, that's it, Judge, thanks.
All right, thank you.
Everybody.
Have a good day. Okay, so next is Mr. Blackwood on page 13.
He's here present, Judge in Maine.
Thank you, Mr. Blackwood. Good morning, sir. The court does find probable cause for aggravated battery with a deadly weapon. Is there a legal objection to that instead of cause harm or disability? Is there a legal objection to deadly weapon versus cause bodily harm or disability?
No, Judge.
Okay, thank you. Hearing nothing from both sides. Okay, and hearing no. So Mr. Linder, first to you, sir.
Your Honor, I believe Ms. Worrell has some information.
Oh, okay. Sorry, Ms. Worrell, hold on, let me mute so there's no feedback. All right, yes, ma'am.
Okay, court released Mr. Blackwood to pretrial supervision. He has with a $5,000 bond on June 9th, 2021, in case number 213375 and then 10-8. At this time, we're going to request a revocation of supervision in that case.
All right, thank you. Mr. Linder, first to you.
Your Honor, even though it is a misdemeanor, I would be asking that the court revoke grant pretrial's request, hold Mr. Blackwood in no bond, considering that the alleged violation is now an aggravated battery. Also, I think the court might remember the battery case. The allegation was that he went up to a woman in a parking lot in front of the building where she lives, grabbed her buttocks. A few days had passed. She saw him again, parked in his car in the same parking lot by the building. And that's when she contacted law enforcement and advised them that she saw the person that committed the offense a few days prior. Additionally, Judge, he has a pending carrying concealed firearm from this year as well. He pled out to a battery in 2019 as well. So it's also possible that the pending battery could be upfiled to a felony battery. He had a petty theft in 2015, Judge. On the new case before the court, I'd be recommending a $15,000 bond, pretrial release of the GPS monitor, and victim contact, no return.
What level, sorry?
Level 2, Your Honor.
He was on 2 already. Okay.
I mean, this is all in conjunction, Your Honor, with the court revoking him. But if the court's not inclined to revoke him, I mean, I'd be asking for a level 1 if he's going to be eligible for release today.
All right, thank you. Mr. Romero, sir?
Judge, Mr. Blackwood did advise me as far as the case he's currently out on. Now, he's been residing in our community almost his whole entire life. Right now, he is not working. However, he has a place to stay. He lives with his mom in Sunrise. Judge, my understanding is the case that he's currently out on, a completely different victim than what we have here before you, Judge. I'm asking at this time, considering that the case that he's out on is a misdemeanor offense, I'm asking for the court not to take any action that doesn't prevent pretrial from going in front of his assigned judge and submitting a warrant. But the case before you, Judge, at this time, we're going to be asking for the court to consider setting a bond of $5,000. He does not believe his mother, who knows that he's in custody, can afford anywhere close to what the state is asking for $15,000, Judge. And we're going to be asking him to be provisionally appointed.
All right, thank you. I do find him to be a danger to the community based on these allegations that there's now a second listed victim with a second set of circumstances. The allegations that he struck him in the stomach with a rusted nail sticking out of a 4-foot-long piece of wood. I am going to grant pretrial's request. He's going to be held no bond on that 21 case. Mr. Linder, I know his number on the CCF because I am revoking his bond on that case as well.
Your Honor, that case number is 21958 CF10A.
21958.
Yes, Judge.
All right, you're going to be held no bond on that case as well. You were ordered not only to not have no firearms, weapons, or ammunition in both two instances, and now it's alleged that you used a 4-foot piece of wood with a rusted nail as a weapon. So you're going to be held no bond on both of those cases. On this law, you're going to be held a $15,000 bond. If you can post your bond, pretrial release level 1, strict house lockdown with a GPS. I have no insurances that I can protect the community from you, Mr. Blackwood, based on these allegations. So that means level 1, and you cannot leave your house. You cannot return to the incident location. You cannot possess any firearms, weapons, or ammunition while your case is pending, and you cannot have any contact with the listed victim, direct or indirect. Meaning you may not know who he is, or you may know who he is, but you cannot call, text, email, social media, send letters, or have a family member or friend send a message to him for you. Do you understand?
The answer in the affirmative.
Okay, thank you. I'll also provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Blackwood. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, sir.
Your Honor,
Yep, I already put no return to.
Judge, do you want us to continue emailing the orders to you, or do you want us to provide hard copies now?
Doesn't matter, whatever you want to do. Okay, thank you. And next is Mr. Watson on page 13. All right, Mr. Watson, good morning, sir. The court does find probable cause for possession with intent to sell or deliver cocaine, possession of heroin, possession with intent to sell or deliver cannabis, drug paraphernalia, and possession of weapon or ammunition by convicted felon. Mr. Linder, first to you, sir.
Judge, if I may be heard on probable cause.
Go ahead.
Thank you, Judge. Judge, as to count 1, the possession of cocaine with intent to manufacture, deliver, Judge, I would ask that the court would only find probable cause for possession of cocaine. There's no indication that the cocaine was, there was any intention to sell or manufacture or deliver. Judge, here the cocaine was found in a single plastic baggie. It wasn't in multiple baggies. There weren't scales nearby that had cocaine residue that would indicate was making money off of this. I would note that there was an indication of intent to sell or manufacture a suspect substance that appeared to be cannabis, but in that instance, there were multiple baggies. We didn't have the same with count 1, which is the possession of cocaine.
Okay, thank you. There was also a large amount of cash. So over the defense's objection, I maintain my finding. Thank you.
Judge, if I may be heard as to count 2 and also count 3.
Okay, what about the heroin, ma'am?
Thank you, Judge. According to the probable cause affidavit, there's no indication that the suspect heroin was field tested. So I'd ask the court to not find probable cause on that count.
Okay, I usually write if it wasn't, and I didn't make that note. It says that it was tested positive for cocaine. Okay, yes, I do see that. It doesn't say that. Mr. Linder, do you see where the cocaine was field test positive?
No, I agree.
Indicated it in page 1 that it was field test positive, though, Ms. Edgley saw on count 3, that's over the defense's objection, indicates count 3 was field test positive in the first paragraph.
I'm sorry, Judge, I thought that that was referring to the cocaine.
The cocaine also says it was field test positive in paragraph 1 of the.
Understood, Judge.
Okay,
Judge,
so in regards to the heroin, though, I don't see that. So Mr. Linder, can you tell me if the heroin was field test positive?
No, Your Honor, I agree. There is no mention about the heroin.
Okay, so does the state need time to perfect?
No, Your Honor, I'm not going to be asking for that.
Okay, so I will not find PC on count 2 only. This is not seeking time to perfect. So on the possession of heroin, without there being any field testing, he'll be ROR'd. With regards to counts 1, 3, 4, and 5, Mr. Linder.
Excuse me, Judge. I'm recommending a $2,500 bond, weapons offense. Asking that the bonds on counts 1 and 3 remain in place, ROR count 4. His history includes criminal mischief 2010, battery 06, aggravated battery against a pregnant victim in 06, possession of cocaine with intent to sell, deliver in 01, 4-year state prison, sale, delivery of cocaine within 1,000 feet of a school, 98, 3-year state prison, possession of cocaine, 97, a year and a day. Nothing further, Judge.
Okay, thank you, Mr. Romero.
Mr. Watson's been residing here in Broward his whole entire life. He works in landscaping. He lives in Hollywood, been living in the same apartment for the past 10 years. Now, his mother is the person that's going to be helping post his monetary bond. She's on disability, so her financial resources are very limited. I was going to be asking the court on count 1 for the court to consider a bond reduction from $2,500 to $1,000 No objection with the ROR on count 2. Count 3, no objection with the standard bond in place. I was going to be requesting an ROR on count 4. And on the bond on count 5, I was going to be requesting a $2,000 bond and be provisionally appointed on his case.
All right, thank you. Mr. Linder, what was the state's request on count 5?
2,500, Judge.
All right, thank you. Just so he's aware, there's a potential the state could file this as armed trafficking. If that happens, then he'll be held no bond and he'll have to go before his division judge. But what's before me, I am going to find, actually, it's not trafficking amount, so I retract that statement. So on count 1, we'll leave the bond in place. Count 2, ROR. Count 3, I will leave the bond in place as well. Count 4, ROR. On count 5, based on the very serious priors, I will set bond in the amount of $2,500. Sir, the conditions of your bond are that you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Understand? Yes, ma'am. He answered in the affirmative.
All right, thank you. Also, you cannot drive without a valid driver's license. The officers indicated that was an issue. So, sir, do you understand you cannot drive without a valid driver's license?
Yes, ma'am.
Is that a yes?
He answered in the affirmative.
All right, thank you. I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic. Mr. Watson, once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Mr. Watson. All right, next on page 14 is Mr. DeJuice.
Mr. Alan DeJuice, come on up. He's approaching, Judge.
All right, thank you. All right, good morning, sir. The court does find probable cause for possession of a weapon, short barrel gun, rifle, or machine. It's alleged it's a sawed-off shotgun. Mr. Linder, first to you.
Good morning, Your Honor. I just need to pull his history, Judge. Your Honor, I'm recommending a $2,500 bond, no firearms, weapons, or ammunition. I just see a 2017 trespass and a 2010 carry and concealed weapon.
Okay, thank you. Mr. Romero.
Judge, he's been residing in South Florida his whole life. He's got a job with a moving company approximately a month and a half ago. He lives with his father. His father's going to help post his monetary bond. Judge, we were going to be requesting a $1,000 bond on Mr. DeJuice's behalf and to be provisionally appointed.
All right, thank you. Based on the allegations, at approximately 2 o'clock in the morning, he was seen and there was a concerned citizen that called in the reports of him allegedly pumping and racking this shot-off shotgun down the street. I am going to impose a $2,500 bond. Sir, the conditions of your bond, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck, sir. All right, next is Mr. Defin, sorry, page 14. All right, sir, good morning. How do you pronounce your name? My apologies. Dolphin. Okay, my apologies. Good morning. The court does find probable cause counts 1 and 2, battery on an officer, count 3, resisting without violence, although there are allegations that this is with violence based on the battery Leo. Mr. Linder, first to you, sir.
Your Honor, I'm showing no history. I'm recommending a $1,000 bond on 1, $500 bond on 2.
All right, thank you. Mr. Romero. You're muted. He's muted, guys. I need to hear from Mr. Romero.
I'm sorry. Oh, if I heard correctly, I believe the state said a $1,000 bond on count 1, 500 on 2.
Correct.
No objection, Judge. We're just going to be requesting a phone order and to be provisionally appointed.
All right, thank you. However, the alcohol influence check is checked off. So once you post bond, sir, you're going to be supervised by pretrial release based on these allegations. You allegedly preventing the officers from executing their legal duties of trying to help a woman and her child out of this hotel room. You cannot use any drugs or alcohol while your case is pending because you are going to be randomly screened for drugs and alcohol while your case is pending. Do you understand?
You understand? Yes, Your Honor.
All right, it's just going to be standard screenings on count one, $1,000, count two, $500, leave the bond in place on three, no return to the hotel. Do you understand?
Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Good luck to you, sir. All right, next is Mr. Oh, yep. Sorry, my apologies. All right, sir, you need to call in with the next business day after you post bond before 11 a.m. Do you understand?
You have to call in tomorrow before 11 a.m. Okay, we'll do.
All right, do you have a phone number you can give pretrial by any chance?
954-638-4966.
Did you get that? One more time, please.
954-638-4966.
4966. All right, good luck to you, sir. I'll sign that property order or phone order. Which one is it?
Order, Judge.
Phone order. Okay, thank you. I'll sign that phone order. All right, next is Mr. Jean Jacques on page 14.
Judge, a property order also, just in case. Yeah.
Oh, okay. Phone and property. Okay, got it. I thought I heard both. Okay. All right, thank you. All right, next is Mr. Jean Jacques on page 14. All right, sir, good morning. The court does find probable cause for burglary of an unoccupied conveyance unarmed. Mr. Linder, first to you.
Your Honor, I see no history, and it would also appear based on the information provided on both you and PC affidavits that he has sufficient ties to the community. Based on that, I'd be recommending an R1 or pretrial, no victim contact and no return, Judge.
Okay, thank you. Mr. Romero.
If I heard correctly, the recommendation of release or pretrial, no objection, Judge. We're asking to be provisionally appointed on this case.
All right, thank you. All right, Mr. Jean Jacques, you are going to be released a pretrial release. That means that you're going to get out today, but you have to call into pretrial release before 11 a.m. tomorrow. So please give your phone number to pretrial before I continue with my orders.
786 970.
Judge, he advised me he doesn't remember the last four digits. You can call in tomorrow at 11 a.m. Once you get your phone and if you remember it, just let them know the last four digits of your number, sir.
All right, sir. So when you call in tomorrow, not only will you have to give them a phone number where they can reach you, but as well as you're going to have to give them an address where you'll be staying tomorrow. Do you understand? Yes?
Yes, ma'am.
All right. You also cannot return to the incident location. Do you understand?
Yes, ma'am.
You cannot have any contact, direct or indirect, with the listed victim. You may not know who they are, but you cannot call, text, email, social media, send letters, or have a family member or friend send a message for you. Do you understand? I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else?
No, Judge.
All right, good luck to you, sir. Don't go back there. All right, next is Mr. Williams on page 14.
Mr. Williams here, present, Judge.
All right, thank you. This is the case that I meant to advise him about the armed trafficking. All right, Mr. Williams, good morning, sir. The court does find probable cause, count one, possession with intent to sell or deliver cocaine, count two, trafficking in fentanyl, count three, committing a first-degree felony with a weapon or deadly weapon, count four, possession of weapon or ammunition by convicted felon. Mr. Williams, please note, even though I found probable cause for what's presented before me, if there's a potential that the state could file an armed trafficking against you, which means you would be held no bond. Mr. Linder, first to you.
One moment, Your Honor.
Judge, if I may be heard as a probable cause on counts 1 through 3.
Okay, go.
Judge, as to count 1, there was no indication that the suspect cocaine was field tested, so I would ask the court to not find probable cause. As to count 2, Judge, there was also no indication that the fentanyl was field tested, so I would ask that the court find no probable cause. And finally, as to count 3, because there was no field test, there is no first-degree felony where the weapon was carried in the course of the commission of the first-degree felony, so I would ask the court would also find no probable cause.
Okay, thank you. So Mr. Linder, she actually is correct. I guess I just missed that, that there was no field testing done unless you can show me, sir. Otherwise, it's the state asking for 24 hours to perfect.
Yes, Judge.
Okay, so I retract my finding of PC. We're going to have to be back tomorrow. Mr. Williams, the state has the drugs were not tested, so we're going to see you tomorrow, sir. The state has 24 hours to perfect all of the counts. So let me see, we'll be back on the 7th of July at the same time, 8 a.m. We're going to see you tomorrow morning. If the state does not perfect, you will be released on your overcognizance and all of the charges. If the state does perfect, then the difference is that we'll see you tomorrow with regards to setting bond, okay?
Yeah. Okay, we'll explain tomorrow.
All right, sir, good luck to you. We'll see you tomorrow. All right, next on page 15, Mr. Lang is a first-time refusal. Mr. Linder, the state did not wish to be heard, correct?
Correct.
All right, so we'll give him one opportunity to voluntarily absent himself. Next is Mr. Amick on page 15.
Mr. Amick is here present with me at meeting.
All right, thank you. Good morning, sir. The court does find probable cause, count 1, possession of cocaine, 2, drug paraphernalia, 3, heroin. Mr. Linder, first to you.
Your Honor, I'm recommending an ROR to pretrial on counts 1 and 3, ROR on 2.
All right, thank you. Mr. Romero?
No objection, Judge. We're asking to be provisionally appointed.
All right, thank you. Mr. Amick, you're going to be released a pretrial release on counts 1 and 3 only, and a straight ROR on count 2. Please provide your phone number to pretrial before I continue with my orders.
Nice and loud, say it right.
954-391-3644.
All right, thank you. Did you get that, Ms. Worrell?
Yes, Your Honor.
All right, sir, you're going to be randomly screened for drugs and alcohol while your case is pending. That means that you cannot use any drugs and you cannot use any alcohol while your case is pending. Do you understand?
Yes, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you will need to reapply to make sure that they keep representing you. Anything else on his case?
Nothing else, Judge.
All right, good luck to you, sir. Please call in tomorrow before 11 a.m.
Thank you. I'm gonna be
No problem. Next is Mr. Klein on page 15, who's waived his presence.
That is correct, Judge.
All right, thank you. The court does find probable cause for driving with license suspended, second or subsequent offense, and his probation violation. He's being held no bond on. He's going to have to go before his division judge on count 2. On count 1, I will order no driving without a valid driver's license. Does your office need to be provisionally appointed?
Yes, Judge.
All right, thank you. And I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. All right, so let me see. Next is Mr. Rivera, I believe, on page 16.
That's this gentleman on my left.
All right, thank you, Mr. Rivera. Good morning, sir. The court does find probable cause. Count 1, grand theft over 750, less than 5,000. Counts 2 and 3 are capiases for driving with a suspended license and failing to register an automobile. Mr. Linder, on counts 2 and 3, does the state have an offer if he wishes to resolve? And what's your recommendation on 1?
One moment, Your Honor. Judge, on 2 and 3, if he wishes to resolve, the offer to be a withholding court cost. I'm showing this would be a first DWLS. On count 1, the offer from the state, recommendation being ROR to pretrial, no return.
All right, thank you, Mr. Romero.
Judge, and speaking Mr. Rivera, he is interested in resolving counts 2 and 3 and accepting the state's offer in exchange for no contest plea. 1, no objection with the state's recommendation of ROR to pretrial for Mr. Rivera.
All right, thank you. Mr. Rivera, please raise your right hand for me to the best of your ability, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can put your hand down and please state your name for the record.
Dennis Rivera.
All right, Mr. Rivera, it's my understanding you wish to resolve your 2021 traffic criminal case of driving with license suspended and failing to register the automobile, correct?
Yes.
Do you understand the charges against you?
Yes.
Is anyone forcing you to resolve that case?
No.
Are you under the influence of alcohol or drugs? Sorry, I couldn't hear you.
No. No.
You need more time to speak with your attorney. Is that a no?
He said no.
Okay, thank you. Do you understand that you have a right to go to trial, but you're giving up that right by accepting the state's offer?
Yes.
Have you been treated for a mental or emotional illness, sir?
Judge, you cut out. I didn't hear you.
It's okay. I asked, have you ever been treated for a mental or emotional illness?
No.
All right, sir. And I'm not asking if you're a citizen. I just have to advise you. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes.
Is that a yes?
Yes.
All right, thank you. And I also must advise you that upon a third conviction for driving with license suspended, it will result in a mandatory 10-day jail sentence. Do you understand?
Yes.
And that a third conviction within 5 years could result in a 5-year driver's license suspension or you being declared a habitual traffic offender by the DMV. Do you understand?
Yes.
There's also potential that a third arrest could result in you being charged with a felony. Do you understand?
Yes.
And knowing all of that, you wish to plead, sir, guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given, and I find that there is a factual basis for counts 2 and 3, and I will withhold adjudication and impose court costs. And Mr. Romero, how much time does he need to pay those court costs?
Judge, we're going to be asking for 1 year.
All right, not a problem. I'll give you 1 year to pay those court costs, Mr. Rivera. So that is that with regards to the 21 case, and with regards to the new law, sir, I am going to release you to pretrial release. That means that you're going to get out today, but you have to call into pretrial before 11 a.m. tomorrow, except you cannot go back to the Walmart and the police reports. Do you understand?
Yes.
All right, please give your phone number to pretrial before I continue with my orders.
954-310-1935.
Did you get that?
1935 or 1925?
1935 or 1925?
15.
115?
1935.
1935.
Got it.
All right, thank you. And does your office need to be appointed on count 1?
Yes, Judge.
All right, thank you. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Rivera. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you. Good luck to you, Mr. Rivera. You're going to be released today. Call in tomorrow on count 1.
Thank you, Your Honor.
Take care. Next, on page 16, Mr. Hadler is a medical reset. Hopefully he feels better. We'll reset him tomorrow. Next on page 16 is Mr. Francis.
Francis is here.
Mr. Francis, good morning. The court does find probable cause, count 1, robbery by sudden snatching without a firearm or weapon, count 2, tampering in a third-degree felony proceeding. I do know he has 0 ties and is allegedly from New York. Mr. Linder, first to you.
I'm just checking to see if he has any history.
He has a New York,
What was that, Ms. Worrell?
he has a New York, he has a-
Oh, yeah. Yeah, I'm showing. Your Honor, I'm showing a drug prior out of the state of New York from last year, that nothing happened with that. I'm also showing from November of last year, reckless endangerment in the first degree out of the Bronx in New York, and it does appear that that case is still pending. Based on all the information we have, I'd be recommending a $5,000 bond on the robbery count, $1,000 on the tampering, and no victim contact, Judge.
Okay, thank you. Mr. Romero, sir.
Judge, Mr. Francis is visiting family from New York. My understanding at this time, he is not working. He was looking for employment. He has his sister here in South Florida who he was visiting with and staying with during his, visit. He doesn't have an extensive criminal prior history. We were going to be requesting the court consider a $2,500 bond on count 1, and we're going to be requesting a $500 bond on count 2, and we're going to be requesting provisionally be appointed on his case.
All right, are you also requesting that he can reside in New York while his case is pending?
Correct, Judge. My understanding he's going back to New York, but I did advise him he's going to have to come back down here to South Florida to address these cases.
Great, not a problem. Okay, on count 1, I'll set bond in the amount of $3,500. On count 2, I'll set bond in the amount of $1,000. Sir, the conditions of your bond, even while you're in custody or in New York, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
You may not know who he is, but you cannot call him, text him, email, social media, send letters, or have a family member or friend send a message to him or any other means of communication that I have not said. Do you understand? And I will again allow you to live in New York while your case is pending, and I will provisionally appoint the Office of the Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. Be in touch with your assigned public defender for the next steps in the proceedings. Anything else in Mr. Francis's case that we need to address?
No, Judge.
All right, back to you, Mr. Francis. Last on the regular docket is Mr. Denmark on page 16.
Mr. Denmark is approaching. He's here at Maine, Judge.
All right, thank you. All right, Mr. Denmark, good morning, sir. The court Justifying probable cause for possession of weapon or ammunition by convicted felon. Mr. Linder, what are his priors?
1 moment, Judge. Your Honor, just noting, I'm requesting or recommending a $5,000 bond, no firearms, weapons, or ammunition. This is a represent of a case where his bond that he posted was actually, his total bond was set at $100,000. The charges were dropped. The state ended up representing the possession of weapon or ammunition by convicted felon case. There are allegations that the firearm involved was discharged. As far as his history, 2010, sale, delivery of cocaine within 1,000 feet of a place of worship with a violation of probation, 50 months in Florida State Prison. 2010, grand theft auto and aggravated fleeing and eluding with a violation of probation, 50 months in state prison. Trespass 09. Nothing further, Judge.
Do you think it was a 25,000 or 5,000?
It was 25. What was it said originally, or what am I
No,
recommending?
what was your recommendation?
5,000.
5,000. Okay, thank you. Mr. Romero, sir.
Judge, I spoke to Mr. Denmark. He had a lot to say. Unfortunately, I didn't have a computer system to verify, but it does seem Mr. Linder did touch on, and seems to be correct, when Mr. Denmark presented. He already posted a monetary bond. I believe him and his family went ahead and looked into their savings, did whatever they could to post it originally a $25,000 bond. Now, he's been residing in our community his whole entire life. He's been looking for work, has been unemployed, but now he's been successful. He actually had an interview scheduled for today. Now, he lives locally here in Hallandale with his mother, where they rent, they do not own. Judge, we were going to be asking for the court to consider a straight ROR on Mr. Denmark's behalf. Considering he already posted bond, it was the state that decided to drop the offense and then refile. Judge, if the court's not inclined for a straight ROR on a case that he's already bonded out previously, we were going to be asking for the court to consider a $1,000 bond on Mr. Denmark's behalf, Judge.
All right, thank you. He can always get an affidavit from his bondsman, Mr. Romero, but I am going to set bond in the amount of $5,000 with an order of no possession of any weapons, firearms, or ammunition while your case is pending, Mr. Denmark. Do you understand? Did he say yes?
You need to say it louder if you understand.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Good luck to you. Once COVID is over, you'll need to reapply to make sure they keep representing you. All right, I know I said it at the beginning of the docket, but on page 17, Mr. Hidalgo is now a third-day medical reset. We'll delete him from the docket. He'll be put back on once he's released from the hospital. So all we have left now are a couple of our other FMN cases. Who do we have first on the FMN docket? I know we have a victim outside on Mr. Hold on. The list of victim is outside. So can we call Mr. Tucker on page 2?
Roy Tucker is here present.
We also have a sign language interpreter.
For which case?
For Travis McCray.
That's not on this docket. It must be the extradition.
At 11 o'clock?
Not on this docket.
Okay, thank you.
Sorry. All right, hold on 1 minute. All right, so this is on Mr. Ty, the listed victim. Sorry, Mr. Tucker, the listed victim is present here in court. Mr. Linder, this is a 3040 motion, has the state charges.
Yes, Judge.
All right, so Mr. Tucker, an information has been filed. Your motion for ROR will be denied. The order of no victim contact still applies, direct or indirect, even while you're in custody. Good morning, ma'am. You are the listed victim. Did you want to say something this morning? If you do, I will need to swear you in. Sorry.
Yes.
All right, please raise your right hand for me. You testify to the truth, the whole truth, and nothing but the truth?
I couldn't understand you.
Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can put your hand down and please state your name for the record.
Yasha Ray.
All right, ma'am, you are the listed victim and you're here without an attorney. So I need to advise you that you previously spoke with law enforcement. So anything you say can be used against you at a later date.
Yes,
All right, ma'am, what is it that you wanted to tell me?
yes, I just wanted to say that I have wanted to drop all the charges against him. And that I would like to drop the stay away order also.
I can't hear you.
I said that I would like to drop all the charges that have been brought against him and also the stay away order.
What is she saying? I can't hear her.
Your Honor, she's advising the court that she wants the charges dropped for victim contact to be allowed. I can't advise the court. She has provided my office with a waiver of prosecution, which we did take into consideration when filing charges.
All right, thank you, ma'am. I understand what you're saying, but today I'm not making any changes. He still cannot contact you. These allegations are an attempt murder. All right, ma'am. Good luck to you. Thank you for being here. We'll have to file a motion with this division, Judge.
Is that it?
All right, next, do we have Mr. Cordovi, Mr. Smith, or Mr. Ty? Those are the last three people.
I think Ms. Cordovi bonded out.
Who?
Ms. Cordovi bonded. The only
Bonded.
one we have left on the second docket, Your Honor, would be Mr. Todd.
Okay, so we have Ty and Smith left.
Judge, I can address Mr. Ty. Mr. Ty is a refusal. I spoke to the deputies. At this time, I'm going to be asking for a mental health screening. I'm going to be asking if the state doesn't have an objection, transferring his case to Judge Lerner Wren.
It's a felony, Hector.
Felony.
All right, and just a mental health screening, Judge.
Okay, no problem. So he's a refusal. I will take no action, but I will sign that mental health screen. This is Mr. Ty on page 5 of the FMN docket. All right, Mr. Smith on page 4.
Mr. Dean Anthony Smith, come on up, sir. Mr. Smith is here, Maine.
All right, Mr. Smith, good morning, sir.
Your Honor, information has been filed. It's been consolidated with this other case.
All right, thank you. So at this point, Mr. Smith, an information has been filed, so your motion for ROR will be denied. Please be in touch with your assigned public defender so they can let you know the next steps in the proceedings, okay? Anything else on his case?
No, Judge.
All right, that's it for our docket, guys. A little bumpy, but hopefully we'll get back in the groove since we're back in person.
Judge?
Which
Yeah, I
page?
was gonna ask that too.
Oh, I missed that one. Okay, thank you. We also have Mr. Howard.
Yes.
My apologies, Mr. Howard. Everybody was, let me know I missed someone. All right, Mr. Howard, my apologies, sir. This is also just on the 3040 docket. So guys, just let me know. Mr. Linder has the state file charges.
Yes, Judge.
All right, so an information has been filed. Mr. Howard, please note that your motion for RR will be denied. You are still ordered to not have any contact, direct or indirect, with any of the listed victims. Please be in touch with your assigned attorney so that they can let you know what the next steps in the proceedings are. Anything else? What about page 6? They said it's a delete because she bonded.
No.
All right, thank you. And did I miss anyone else?
No, Judge. Steve, have one.
All right, thank you, guys. All right, everybody have a great day.
You too, Judge.